Justice of the Appellate Department. Hear ye, hear ye, hear ye. All persons having business to be before this court will draw near to their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 881, People v. Stroud. Counsel, proceed.
Good morning, Your Honor. May it please the court. A hunch, even a professional hunch, is not a substitute for reasonable suspicion or probable cause. Those aren't my words. Those are the words of this court and the Court of Appeals, as early as 1978 in the Sabatka case. 4 years after Chestnut was decided, that was the holding in Sabatka, telling us and warning us about the use of a hunch, really a term of art well known to police officers. It continued through Stock in 2008 and right up until last year in Hernandez.
So here there's a claim during cross-examination. He said, so this was basically a hunch, and the answer was yes. But later on there was a discussion, pull the car over because progressively smelled marijuana.
Yes. There are actually two statements of the hunch, Your Honor. One comes as they're pulling out of the Mandela Market. They come in and they pass the Stroud vehicle, and they have a hunch that there's a smell of marijuana. They then follow the Stroud vehicle out of the Mandela Market.
Right. It's clear that they claim they smelled it while it was in the parking lot, but waited for the car to go. And then they said they smelled it as it drove by.
Well, what they actually said, and the record's not very well developed on that, but what they actually said was they pulled out of the market at Mandela's, went north on Jefferson, followed it for several blocks. We don't know how many car lengths there was in front of it. Was it 1, 2, or 6? And they said that they smelled some marijuana. But most importantly, when they got to the actual stop on cross-examination, the witness said, Officer Schultz, that he could not definitively say that the smell was coming from the Stroud vehicle, even when he approached it, the vehicle. And
because there's no dispute that there was no marijuana wafting through the windows.
Absolutely right. Not only that, there was no furtive movements, there were no vehicle and traffic violations, there was nothing that justified the stop, except for this claim, which borders on the physically impossible, that they are back in their own car. Their windows are down, I'll grant that, but their heat's blasting, and they're saying that the windows in the Stroud vehicle are all up, and they're traveling at least, has to be several car lengths ahead of them, and they claim that they smell the marijuana. But when they get to the actual vehicle, and Stroud is cross-examined, he says, I can't definitively say that it came from that vehicle. That, to me, is the end of the analysis at that point, because a hunch doesn't supply the reasonable suspicion.
Now, when he said he couldn't definitively say if it was from that vehicle, is that in the parking lot or after they followed him?
After they followed him and stopped him, couldn't definitively say. In fact...
Counsel, let me ask you a question about the hunch. You're leaning heavily on that testimony, it seems. And there seemed to be, on redirect examination, some rehabilitation of that. The prosecutor asked specifically, now you've said hunch, did you intend it sexually on basing your testimony on your experience and training? Does that cure the hunch language that you're relaying on? In other words, the officers both testified that they had both been through training at the community college. They both had years of experience. I mean, not a lot of years. I think one had maybe 5 years, one had 6. So these are not overly experienced officers, but they certainly testified to numerous arrests relative to marijuana and smelling marijuana.
So there's two questions that you posed, Your Honor. The first one was whether or not the redirect cured the testimony that it was a hunch. And it doesn't. Because what he says is, he says that, did you believe it to be coming from there? And sure, I have a hunch that the Bills are going to make the Super Bowl this year. That's my belief. If someone asks me, what is your belief about that? I'd say, that's my belief, but it's based on a hunch. Because I don't...
Counsel, they did say they smelled it at least 3 distinct times, right?
Say it again, Your Honor.
They said they smelled marijuana, either burnt or burning, at least 3 different times. They smelled it when they drove past the car. They smelled it when they were in the parking lot, and then they smelled it when it drove away.
Interestingly, Your Honor, they never were able to definitively state where it was coming from. At the Mandela's market, when they said that they smelled it when they first pulled into the market, they were asked on cross-examination, well, were there other cars in there? Initially, they said on direct no. Then they said there's 4 other vehicles there, so it could have been coming from there. Yes. Could it have been coming from the market? We don't know. There are people that hang
Counsel,
outside.
I've never been impressed by people that say it could have been, because there's much that could be. But I thought they said, we smelled it, that was the car that was occupied on the road. The car moved away, we smelled it again. We followed the car, we smelled it again. That seems to me at least 3 times that it's direct smelling and not just taking a hunch.
Well, in order for that to be successful, to be the foundation for their opinion testimony, they have to go back to Justice Whalen's question, have the requisite training and experience. So let's talk a little bit about the training and experience. What they said was, we went to the academy. Well, was it 1 day? Was it 1 hour? Was it 1 month of training? They never developed that on the record as to what the training was.
Counsel, didn't they also say they smelled it daily in the course of their job experience?
They did say that there was some familiarity with it by virtue of their working on certain shifts. But here's what they said when they had the opportunity. When the softball was thrown for them to bat out of the park and to describe what their experience was and their expertise, this is what they said. Are you familiar with the distinction between, this is Briggs, fresh versus burnt or burning marijuana? This is their opportunity to convince on the record this trial judge. Burning marijuana, it has like the after smell usually in the area. And fresh marijuana is just smell like it's just in a bag, like it's not so it's not so stale like burning marijuana. That's important because, as you know, one officer says it's burnt and one says it's burning. And Schultz's testimony about his expertise and training is even worse. Here's the opportunity. How do they differ, fresh and burnt marijuana? Well, burnt marijuana, its odor
So is it your claim that it makes a difference as to whether it was burnt or whether it was stale? Could they not have smelled marijuana that had been extinguished?
Well, the point, Your Honor, is in this record, given this record of evidence, one officer says it's burnt and one says it's burning. And they both say there's a big difference between the two. But in their testimony, they can't distinguish between the two. Because when Schultz says, what Schultz says is that, burnt marijuana, its odor is stronger. Fresh marijuana, it smells more. I don't know, it's moist.
But there wasn't a claim here that they smelled the fresh marijuana that was found. There was a package of marijuana that was found,
2 baggies were found, correct.
and that's not what they claim that they smelled.
No, one says it was burnt and the other says it was burning.
Well, counsel, let me ask you this. What's troubling to me in this particular case is not only that inconsistency between these officers. One says it's burning, one says it's burnt. And the first officer, I think it might have been Briggs, well, I'm not sure, maybe Schultz,
Schultz was first.
indicated that he thought there was a real distinction between the two,
Yes.
burnt and burning. One that apparently they've been trained about. And you're pointing out the fact that the training has not been developed on the record. They have the burden of proof on the motion with respect to this. But there's other inconsistencies, right? The inconsistencies with respect to the number of cars in the lot initially. There's inconsistencies with respect to, I mean, if I read the transcript, this was a driverless car.
That's true, they both said they were passengers.
Yeah, and so I just think that there are a number of inconsistencies in the testimony that haven't been explained.
I understand that there will be inconsistencies when 2 people view a single event. I appreciate that. I also understand that great deference is given to the trial court and that evaluation of credibility. But it's not carte blanche. And this court has said on several occasions, look to see what disturbs the credibility below. Is it contradictory? Is it manifestly untrue? Is it physically impossible? Is it contrary to our experience? That's the criteria that we used in our brief to highlight all of these inconsistencies. Who was driving? We were both passengers. Where was the straddle vehicle in relation to your car? Nothing on the record. We don't know if it was a half a mile away when they claimed to smell it. That's important because it goes to the physical impossibility of smelling the marijuana. Color of the Stroud vehicle, we don't know. Was it burnt marijuana versus burning marijuana? Two different opinions. Source of the smell.
Well, is one of them necessarily wrong, or could they both be right? One smelled the burnt one, and one smelled when it was burning. Is it necessarily inconsistent, or could there be both?
Well, it is inconsistent because the basis for the stop is the claim of burnt marijuana. That's the basis. And they do say, Your Honor, that there's a big difference between the two. They never develop on the record how the difference is material, or they never develop on the record what their training was to establish that. But Schultz says we went to the parking lot because people hang out there all the time. They smoke weed and drink on the ledge and they fight. Briggs says, no, that's not why we went. We were just patrolling the area.
In fact, Briggs not only just says that's not why we went, my reading of the testimony is, Briggs says, I don't remember ever seeing any fighting there, and yeah, I don't know that people smoke there or drink there, which is directly contrary to his partner.
Absolutely. They say the Stroud vehicle was parked in front of Mandela's Market, right in the front.
Could not the two partners have different experiences with that particular area?
Well, they may, but they claim that they've worked together for a while and they both patrol the area all the time. You would think that something as obvious as that's known to Officer Schultz would be known to Officer Briggs as well.
And what do you say with respect to credibility being something for the trial court to assess?
What I say to that is that I understand that the trial court is given great deference with respect to credibility and demeanor, but it's not a carte blanche. And when you have testimony in the record that's contradictory, that's difficult, that's beyond our common experience, in some instances physically impossible, then you have the obligation to review the record and make a credibility determination de novo. And this court has done that in Davis and in Williams. I mean, the contradictions, they're shown photos and they say, first they say one car, then they say 4 cars, then they say it was parked in front, then it was parked on the side. There's just so many contradictions.
During the testimony, at one point, Briggs, which was also troubling, Briggs was asked what I thought was a relatively simple question about the color of the vehicle, I believe it was. And his answer was, well, it seemed that was a long time ago, I really don't remember. Which calls into question, I think, his memory of the incident itself.
In addition to that, Your Honor, the same witness says, I don't remember anything, but all I know is I smelled marijuana. Well, that's the safety valve. That's where they go back. They go back to that because that's rote testimony, that's formulaic testimony. So this search and stop, it fails because they haven't established reasonable suspicion. They have, in the record, on 2 occasions, they say it's a hunch, and that cannot be rehabilitated. The training and experience of the officers does not provide the necessary foundation to provide that expert or lay opinion. And finally, there's such lack of corroboration of the two, contradictory on so many material differences that really make it important that the credibility is at issue and should not be sustained.
Counsel, you should wrap up at this point.
Our final point really is a direct attack on the outdated and obsolete plain smell doctrine. We spent a lot of time in our brief going after the Chestnut case and saying why it's no longer.
However, although the law has been changed with respect to marijuana, at the time that this incident occurred, we are to base the decision on the law that existed at the time.
So ironically, Your Honor, when 22205 was enacted, it was made effective March 31st, 2021. 13 days after Kaishan Stroud was sentenced. Had he waited 13 additional days to participate in a sentencing that was delayed 18 months because of COVID, there's a strong argument that could be made that because this statute is procedural in nature, that it could be retroactive. And frankly, if this statute were applicable now, we all know what the outcome would be. We wouldn't be here, and Kaishan Stroud would not be facing 7 years imprisonment. Thank you, Your Honor.
Thank you, Counsel.
Morning, Your Honor. The direct assault on the Chestnut rule is not preserved for this court's review. They did not raise it below. In any event, as Justice Strautman noted, it was the law of the land at the time this case was decided, and I would encourage this court to reject that argument.
Counselor, what do you say with respect to the claim that all we have here is a hunch?
I think the problem there, Your Honor, is that defense counsel was obviously trying to use that term as a term of art, and the officer was merely using it colloquially. When he was rehabilitated, he said that that hunch was based on his training and experience. The training involved the police academy, specifically.
What about the claim that the officer was unable to articulate what that training was?
Your Honor, I know the difference between the smell of cilantro and saffron, but I could not articulate that difference to you in 100 years. So I can understand why he might have struggled with it.
But if you're trained, counsel, if you're trained on this very topic, right, you go to school for it, and you're trained to distinguish between the two, should you not come out of that training with some ability to articulate it? And if you can't, how do you persuade a finder of fact in a suppression hearing such as this when you got the burden of proof?
I was merely trying to state, Your Honor, that it's difficult to articulate the difference of two smells. But they did their best with it. And I think there's very strong corroboration for what they
Well, your
testified.
opponent has highlighted the testimony of them doing their best. And he did it for a reason. It was very slight in terms of trying to articulate the difference between those two. And that was an important aspect of this case. Wouldn't you agree?
I would, Your Honor, but the fact remains that burnt marijuana was found in the car, and that's what they testified that they smelled. So there's strong corroboration.
Well, one said burnt, one said burning, which is another problem altogether, right? They're both driving in the same vehicle. They're both having the same experience, presumably. And one says there's a big difference between burnt and burning, and the other one says it's burnt, and the other one says it's burning, yet the record doesn't tell us what the distinction is.
Your Honor, I think Justice Nemore pointed out that it's possible that it was burning at the time they initially passed and that it was ultimately burnt and therefore
But the only thing in the
extinguished.
record indicates that it wasn't hot. It was cold.
Well, there had been a passage of time, Your Honor. The defendant could have extinguished it in the ashtray and it could have lost its residual heat. I would just point out that there was corroboration for their detection, both in the form of their findings in the car, the physical findings, and in terms of defendant's confession that they were just smoking weed. They weren't doing anything wrong.
When did defendant indicate that they were smoking weed?
When they approached him, Your Honor.
He said that when you approached me, we were smoking weed?
He said, "We're not doing anything wrong, we're just smoking some weed," I think.
Didn't indicate the time frame for that.
I think he said smoking, but no, he did not say at, 2:55 a.m. That's
Yeah.
correct.
Or presently, or we just finished, and they didn't see any smoke coming out of the car, right?
Billowing out of the car, no, Your Honor.
Right.
There was no testimony of that. That's correct. I don't know if there's anything else. No, unless the court has any other questions, I'll leave it there.
Counsel, thank you. Case 882, People versus Gilbert. I should indicate, counsel, as your case is being called, you'll see our court attendant is going to be cleaning the areas that have just been occupied, so just give them a minute to do that.
Yes, Your Honor.
Thank you.
Good morning, Your Honors. May it please the Court. Danielle Wild, appearing for Ms. Gilbert. This is no doubt a devastating case, and the facts of it are largely undisputed, and that my client's senseless actions resulted in her friend's death. But the weight of the evidence does not support the jury's finding that Ms. Gilbert intended to cause her friend serious physical injury during the course of this fight.
Well, she did bring a knife to what was supposed to be a fist fight, didn't she?
She did, Your Honor. But the record shows that the sheath of the knife was on when it ensued, and that at some point during this 30-second chaotic fight, the sheath came off. It's unclear how the sheath came off, whether it was intentional, whether it was mistaken.
But there were
the
a
sheath
number of stab wounds, including the fatal one to the neck.
Yes, there were 4. There were 4 stab wounds, and the one to the neck, the testimony was that that was likely the fatal wound.
Counsel, is it important that the stab wounds appear to be like plunging stab wounds as opposed to slashing?
Well, Your Honor, there was some testimony that was brought out on cross-examination by defense counsel that they were inflicted at different angles, which does suggest that there was some
There were
reckless
different
motion with
angles,
the
counsel,
knife.
But wasn't the knife 4 inches in length and the neck wound was 3 3/4 inches, meaning that it was plunged almost all the way to the hilt?
I don't recall the exact length of the knife, Your Honor, but I do know that the stab wounds ranged from 3 1/4 to 4 inches in depth. But as the record, this video really speaks for itself. I mean, it was a 30-second chaotic fight, and at the time that the fight was broken up, the victim was still standing.
But in addition, you do, as my colleague just mentioned, look at the result. And the objective evidence is the manner in which the knife was actually used, the depth of the stab wounds. You can't just freeze frame and not consider everything in context.
Of course, Your Honor, and I agree, and considering everything in context, it doesn't show that Ms. Gilbert intended to cause serious physical injury. It's frankly not enough
What
that
about
she
the
may
other
have...
items that were on the porch when the police first arrived and then suddenly they were elsewhere?
Sure, the conduct after is certainly something that the court can consider, but it's not conclusive. Frankly, she could have, in a moment of panic, after the fight and realized what the severity of what had happened, moved them down to the basement of the laundry room.
Including the 911 call?
She did call, my client is the one who called 911, and the people in their recitation of the facts, tried to slow down the time that all of this took place. It's not that there was a substantial period of time from when the victim fell to the ground, when my client walked back to the porch, came back, called 911. We were talking about a matter of minutes. The timestamps on the video and of the 911 call make that very clear, that this was a very quick situation, and the court can certainly look at the video itself and consider the testimony. If the court is inclined to affirm the conviction, it really should nonetheless reduce the sentence in the interest of justice. The people argue in their response brief that there are no extraordinary circumstances present in this case, and that the court below adequately considered the mitigating factors and didn't abuse its discretion. But this court has repeatedly held that extraordinary circumstances and an abuse of discretion are not required for this court to reduce in the interest of justice. And frankly, all of the circumstances of this case compel a shorter sentence for Ms. Gilbert. And on the other point raised in our brief, the prosecutorial misconduct issue, I'll rest on that brief unless the court has any questions.
Thank you, counsel.
Thank you.
Morning, Your Honors. Kaylin Porter on behalf of the people. I'll just echo a comment by Justice Niemoyer that this defendant did bring a knife to a fist fight. The video here is pretty instructive. I did mark the timestamps in my brief, but you see the defendant charge across the lawn and attack the victim who's standing there. It's undisputed that she's standing there completely unarmed, repeatedly stab her over and over as the victim continually steps backward. And as Justice Winslow pointed out as well, this knife was 4 inches long. The victim was stabbed numerous times by the defendant with essentially the entirety of the knife going into her neck, piercing through her collarbone and into the bone that surrounds the spinal cord.
What do you say with respect to the sentence being harsh in light of the reason for the fight, that they were friends, etc.?
I would say that makes this all the more senseless of a killing. The defendant and the victim had been friends for a long time. This was a brutal, senseless act, but that doesn't really doesn't mitigate the violent nature of the act. The defendant chose to bring a knife. She armed herself with it and waited for the victim to show up. She faced up to 25 years for this killing, and the court expressly considered all of the mitigating circumstances that were highlighted by defendant on appeal, her lack of a criminal history, and her expressed remorse at sentencing, and took those into account and sentenced her to less than half of the maximum allowable. So I
Counsel,
would,
what about the claim regarding the showing of the photograph that was unnecessary?
I would submit that that's entirely unpreserved. The case law that's relied on by the defendant is regarding the admissibility of the photograph. This photograph was admitted without objection, actually, on a previous witness where it was used to identify the victim. It was used.
Would that be all the more support for the argument that it was unnecessary and that it was being used to invoke emotion?
The prosecutor had to identify the victim with this witness. That photograph that was used, so there were 17 postmortem photographs of the victim. That photograph that was used was, I would submit, the most appropriate one that the prosecutor could have used. There was a sheet that was tucked around the victim's, all around the victim's injuries. You couldn't see any blood or any injuries.
But you cannot argue that it's not a photo that does in fact evoke emotion, seeing her in the manner that she's presented. There are times when other photographs that, when the person is alive, to identify who that person is, have been used at trials. And you're saying the only photograph available was this one?
Of the photographs that were admitted, Your Honor, but there's no rule that a prosecutor can't use a postmortem photograph to identify the victim. This photograph was used on several witnesses as a way to identify the victim. As I stated, there was no apparent injuries. It was simply a photograph of the victim's face. And as for any prosecutorial...
But the manner, again, you can't argue, and I understand, and I'm sure defense does. There are a number of things that are prejudicial to the defense, but this photograph does evoke emotion.
I wouldn't say that then evoking any emotion from the witness would necessarily be prosecutorial misconduct. As I stated,
No, not necessarily. If there was another way to do what you're saying, simply identify her, not with respect to the cause or the intent elements that are necessary. You're saying that this particular photograph was used just for identification. Is that correct?
It appears that
And
way.
that there's no other way she could have been identified by any other photo?
I suppose they could have brought in a pre-mortem photograph, but I don't see how that would be any less prejudicial. It would essentially be showing the jury a before and after photo of the photographs that were admitted in evidence that are...
Well, I would submit to you, there is a difference between a corpse and a photo of someone alive.
Unless the court has any other questions, I'll rely on my brief.
Thank you, counsel. Case 883, People versus Yamas. Counsel, proceed.
Thank you, Your Honor. May it please the court. My name is Peter Sosrabuda. I'm here from Hodgson Russ, LLP, on behalf of defendant appellant Antoine Yomas. This court can and should reach the issues raised by Mr. Yomas regarding the trial court suppression ruling because Mr. Yomas did not validly waive his right to an appeal. In the aftermath of the Court of Appeals cases like People v. Thomas, People v. Bisono, it is clear that there needs to be a differentiation in a trial court's plea colloquy that explains that there are certain rights that the defendant is forfeiting as a condition of the plea agreement that he's entering into with the prosecution.
Let's assume for the sake of argument that it's invalid. Why don't you tell us with respect to your claim that the plea was improperly taken?
Yes, so there's no explanation given by the trial court that there's certain appellate rights that Mr. Yomas is agreeing to waive as a condition of his plea agreement, but that there are appellate rights that he's retained and that he cannot waive.
And you're saying that is required?
Yes, Your Honor. Without that differentiation, you cannot avoid the danger that is, warned against in cases like People v. Thomas, that the impression will be given to a criminal defendant that agreement to plead guilty constitutes an absolute waiver of a right to appeal. If you don't make that differentiation clear.
But presume we get passed into the merits. Can we review the merits of the suppression hearing? Didn't the defendant say, oh, don't bother putting the ruling or the reasons for the suppression on the record? Hasn't he prevented us from reviewing it, even if we could?
You can review this, Your Honor, because there was a final determination put on the record of a suppression ruling, and Criminal Procedure Law 710.7 subsection 2 says that when there is a final ruling put on the record, an appellate court.
I guess what the question is that he ultimately waived it, correct? Did he not waive the findings?
So his defense counsel, when they announced or told the trial court that they had reached a plea agreement, he said, yes, Your Honor, we're not asking you to put your findings on the record.
So we don't have the findings before us, correct?
You don't have express factual findings, but what you do have are all the facts that were present in the record before the trial court.
Do we run into a Concepcion issue?
I don't believe so, Your Honor, because I believe this court, just given the factual record, the full factual record that is not in dispute, can rule as a matter of law whether the statements should have been suppressed. And it is clear, given the undisputed facts, that there was no waiver of his right to silence. And in fact, there was pretty clear indication that he had invoked his right to silence by refusing to answer any substantive questions during the first custodial interview, which occurred at his then girlfriend's apartment. So given that those facts are undisputed.
You agree at the apartment, he was given Miranda, correct?
He was.
And he never specifically said he did not specifically request an attorney, though, did he?
He did not request an attorney, but what's at issue here is not the right to counsel, it's the right to silence, and the Miranda warnings cover both. And
there were no inculpatory statements made at the apartment.
no, Your Honor,
And he went to the police station.
He did.
A substantial period of time passed?
An hour and 11 minutes. He left the custody of Detective Carney, who was the officer who read him the Miranda rights. He was taken by different either officers or detectives of the Erie County Sheriff's.
So were they required to be read again, or were the officers supposed to, as you say, honor his indication by not answering that he was invoking his right to remain silent?
Before the second custodial interview began, they were required to read him his rights again. Now, had he said, I need an attorney, they would have had to honor that and allow him to speak to an attorney before attempting to interview him a second time. But because he had not expressly requested an attorney, but instead had manifested a pretty clear intent not to answer any substantive questions, to remain silent, if they were going to interrogate him for a second time, they needed to re-Mirandize him. And it's undisputed, that second set of Miranda warnings was not given.
Wasn't he essentially in continuous custody of the officers from the time he was at the apartment, in the car, and then back at the police station? And it was a non-coercive environment? In other words, they weren't, drilling questions at him about where he was and what he did, but rather it was more conversational in tone. And doesn't that factor into our decision?
Well, so he's not in the continuous custody of the officer who interrogated him.
Does he have to be in the continuous custody of that sole officer, especially in this case where the officers that transported him did nothing but transport him, and the record does not reveal any questioning during that police ride?
Well, frankly, Your Honor, we don't know what happened during that transportation.
But there's no statements being offered against your client based upon what transpired in the police ride, right?
Correct. That is correct, Your Honor. I just think that the law is clear if I have invoked my right to silence and you leave and come back, regardless of whether or not I'm still in custody or whether I've left custody, those Miranda warnings need to be read again, and that prevents against a danger of,
So the question is whether he validly invoked his right to remain silent.
So, yes, and we believe, given the factual record, it demonstrates a pretty clear invocation of his right to silence. But I also think, even if the court were to find that there were not an invocation of right to silence, what you don't have present at all is a waiver of his right to silence. He did not waive any Miranda rights at the apartment. And because there's an absence of a waiver, again, there needed to be a second set of Miranda warnings given to him when he got to the sheriff's office.
Thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honors. It's our position that we don't get past the waiver of the right to appeal in this case.
Well, humor us and let's get past it.
It is a rather dry subject, I'll concede, Your Honor.
Did he waive Miranda?
Our position is that he did, Your Honor. I understand that he was silent on some issues, but it was not.
Well, he was clearly silent, absolutely silent with respect to the apartment, right? In terms of question and answers about what transpired, other than pedigree questions.
Right, but he was not absolutely silent, because he
but I
did
mean-
answer pedigree questions.
Yeah, pedigree questions, but that's not enough, right, for a waiver of Miranda, the answering pedigree questions. Can we
It
agree
was
on
my
that?
understanding that it needed to be, unqualified, and in that sense, I would say that it's not.
Right, so when does he waive Miranda warnings? Is it back at the police headquarters, or where he's questioned the second time an hour and 11 minutes later?
I guess I would suggest that he waived at the scene, but then again, you could also say that he waived at headquarters when he voluntarily spoke to them in a relaxed, non-coercive environment. Yes, Your Honor.
Okay.
Unless there are any questions, I'll stop there.
Yeah, thank you, counsel. Case 884, People versus Rodriguez.
Good morning. May it please the court, Brad Keene for defendant appellant. We submit that the matter should be remitted for resentencing with a pre-sentence report that meets the statutory requirements. We acknowledge that the people...
I know you addressed it in your reply brief, but as you recognize a letter that you weren't in possession until later on, why doesn't that letter comply or comport with the...
So, yep, as you indicated, that's where I was just going to go. We acknowledge this letter, and I think the letter speaks to the nature and circumstances of the offense, but it doesn't get to the social family history, the economic status, the education, the personal habits, the things that are so necessary for programming at the correctional level, and that are really important for this particular defendant. If, however, this court does not want to remit for resentencing, it should at the very least modify the order of protection. So I think this case is very similar to the Davis case cited in the brief. NL, the alleged victim, expressly requested the ability to speak to appellant and her child.
Is the court prohibited from issuing an order of protection over the alleged victim's objection?
I'm sorry, say that again.
Is the court prohibited from issuing? Is that what you're arguing? She didn't want it, so the court shouldn't have issued it.
Right, yes, the court shouldn't have issued, I think it was an abuse of discretion. It was similar to the Davis case. In
But
that
the
if
court
you-
did have the discretion to issue it over her objection.
Certainly, but it could have been a no offensive contact.
But counsel, let me ask you this question. Didn't the court give the out by saying subject to family court?
It did,
I mean,
but
so wouldn't that be the proper remedy at this point for them? If this appeal's been pending, just go to family court, make an application, so the court didn't deny, in a sense, ever getting it. The court gave them an avenue to get it.
we understand that, Your Honor, but I think I would be doing a disservice to my client if I didn't bring it up now
I
upon
recognize
his, specific request.
Okay.
But there are some egregious circumstances here with respect to the conduct that was witnessed by others, and there was a child present.
Absolutely, Your Honor, but
And so the court had the right to, of course, consider those factors when it chose to issue an order of protection over her objection.
Absolutely, and I think this goes back to my initial point, that the court, when it did that, I don't think adequately understood the background of this defendant, and also didn't adequately weigh the defendant's, I think, extreme acceptance of responsibility and remorse, and acknowledgement of what the crux of his real criminality is, and that's an alcohol addiction. Unless there are questions, I'll rely on the brief.
Thank you, counsel.
Good morning, Your Honors. Brad Osler on behalf of the people. May it please the court. I'd submit that the albeit somewhat brief letter form pre-sentence report was adequate under these circumstances. It was a sort of a universal disposition. It was.
But you don't dispute it would have been better if the proper format had been submitted.
I would agree with that, and there's nothing to stop them.
But there was no objection to the PSR.
No, and I think.
And might it have been a strategic decision not to put a full-blown PSR in front of the court, given that they already negotiated the plea?
Possibly. I mean, the defense was facing a no worse than kind of situation, and as I was about to say, they were dealing with a disposition that was going to satisfy 3 different cases, essentially. So, but certainly I think the defense, presented the evidence that it wanted to the court, and I think that's indicative of the fact that the court had enough in front of it. And then briefly, with respect to the order of protection, I think the court allowing it to be subject to modification by family court is certainly an appropriate exercise of discretion, and the fact that it was a full order is merely reflective of the defendant's history of failure to comply with similar orders in the past.
Thank you, counsel. Case 885, People versus Dollison.
Double header for me. In this one, we assert that replacement counsel should have been provided. Appellant sought replacement counsel due to communication issues, lack of visitation, and he felt the defense counsel was making him take a plea. The trial court...
Didn't the court specifically ask him at the plea when they said, do you want to be heard about your written request for new counsel? And the defendant responds, I'm willing to take the plea.
So, Justice Nemoyer, that was on the June 20th proceeding. So back on June 13th, the trial court's response to appellant was that he focused on conflicts that appellant had.
That was the original oral request, and then there was a written request. But
Correct.
before he sentenced him, the court did say, do you wish to be heard on either of the oral or the written? And he said, no, I'm willing to take the plea. The court should have said, too bad, you got to make an argument anyways.
No, not at all, Your Honor. But because of the court's reaction to appellant's request on June 13th and the June 15th letter, at that point, appellant does not believe anything that he says. He concludes, no matter what I say, the trial court is not going to give me replacement counsel. So I think you're dealing on June 20th with an appellant resigned to the fact that he has to take this plea. And that's because due to the prior inquiries on June 13th and from June 15th, it is not exploring the nature of the disagreement or exploring the potential for resolution. There is, I think, a preoccupation with trying to get this case moving and resolved. So unless there are questions on that issue, then we'll rely on our brief.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Josh Tonner on behalf of the people. This is a case where I think the fact that the defendant didn't move to withdraw his guilty plea or vacate the judgment of conviction really matters because there's no record developed showing that the defendant felt resigned to his fate with regard to his application. What the record does show is that on both occasions in which he expressed some concerns about defense counsel or dissatisfaction with him, before the court could get to the point where it could ask him to explain what's going on with the relationship with counsel, the defendant indicates on both occasions that he either, on the first occasion on June 13th, wishes to accept the plea but wants some time to consider his options, and then on June 20th expressly says he wants to accept the plea as offered. So I think this is a case where he abandoned any, he didn't even really ask for substitution of counsel, he asked to express his dissatisfaction. But he abandoned that when he decided to plead guilty while still represented. I would submit on a brief for the remainder of the argument.
Very good, counsel. Thank you.
Thank you.
I'm going to use this opportunity to remind counsel, both in their seats and when they approach, to make sure you keep your mask up above both your nose and cover your nose and mouth. If you can't do that, I'm not going to be able to allow you to continue to argue. Please, we're going to call now 886 in the matter of Charlene Childers versus Gunkel.
Morning, Aaron. Please, the court. Paul Watkins, the attorney for the children. I set out in my brief the various arguments I have. The main one is it's unclear how this court can have effective appellate review without the actual order that the appellant is requesting be modified before you. So I think just on that basis alone, the matter should be dismissed. And no, the appellant can always go to refile, and at this point attach the order, and then the court would have it, and the court and you would have it. That's my main argument. I made other arguments in there as no change of circumstances in the Lincoln hearing, but unless there's questions by the court, I'll submit.
Thank you, counsel.
Thank you.
Case 887, in the matter of Tyrone O.
Good morning, Your Honor.
Counsel, it appears that you're alone.
It appears so.
Okay, very good. Please proceed.
Good morning, Your Honors. This is Joshua LaRock on behalf of the Onondaga County Department of Children and Family Services. Just a few minutes of your time. This case, I would ask that the court uphold the lower court's denial of an adjournment. Clearly, Family Court Act 1048 empowers the trial court to grant an adjournment when good cause is shown. In this case, Ms. Gorton, or Ms. Gorton's attorney, hadn't been in contact with her, with his client for an extended period of time. I believe the first court appearance was December 16th, 2019. She failed to appear then. She failed to appear on the date of trial, which was January 27th, 2020. And at that time, her attorney had indicated that he was unable to articulate a reason why she failed to
I'm
appear.
going to stop you for a second. Counsel, can you identify yourself, please?
I am, for the appellant, I'm sorry, I just stepped in the bathroom and saw my case came up rather quickly.
Well, then have a seat, counsel. We're going to allow you to argue.
Thank you.
Counsel, do you want to take a moment and we'll let appellant go forward? Right?
Thank you, Your Honor. May it please the court. For appellant Lillian Gordon, we submit that the denial of an adjournment in this case involving fundamental rights of Ms. Gordon was improper. First of all, it was the first request by her attorney on the docketed case. There had been a comment by the caseworker, Ms. Jennifer Pilata, that the parents of the child had in fact contacted her and said that they intended to be in court that day. Although they were not, that did provide some reason for the court to consider an adjournment in this case.
Well, counsel didn't say he knew where she was or that she asked him to get an adjournment. She just wasn't there.
She wasn't there. She had contacted her caseworker, her Syracuse caseworker, relatively recently, within my understanding, within a day or two of the appearance, saying that she intended to be there and that they had been working on.
Well, she did have a history of not appearing. And
She
it
did.
appeared she lived up to that history and didn't appear this day.
That's true, Your Honor. She did have an inconsistent attendance record at best. That is acknowledged. I would submit that there were reasons for this that needed to be looked into by the court. There had been a relatively frequent communication with her and her caseworker. They'd met with either her or the one from Monroe County, by my count, 9 times during the course of the proceedings. There were multiple phone calls and texts. There was communications recently before the first court appearance on this matter, after it, saying that in fact the bus passes that were to be mailed and wired to Rochester were not there. And then again, on the same day, the father did contact his attorney to say that they were inquiring again about bus passes and about visiting their son.
And your argument is because there's such a fundamental right with respect to term involved here that is terminating one's parental rights, that the court should have exercised its discretion despite her prior non-appearances, in favor of the mother and allowing an adjournment in this particular instance.
That is what we're saying, Your Honor. I think that although there is discretion by the court in this matter, it's significantly narrowed when the fundamental rights such as the termination of parental rights are at stake. And I think also the other big factor in this case that needed to be taken a little bit more seriously, in my opinion, and we submit by the court, was the matter of the parents' poverty. This was clear in the record. The AFC himself acknowledged it, calling them dirt poor, saying that they didn't have a lot of options. The judge was on notice about respect to SSI benefits and veteran benefits. He asked at the dispositional hearing, he asked the parties, well, do we know anything further about the fact that the benefits of the parents may have been being procured improperly by the adult children, and therefore they didn't have access to that? The question was nobody knew. It gave another reason to slow the proceedings down a bit. We cite a case in Ray W., I believe there are others, to say that where issues of poverty come into play, it's incumbent upon the court to be able to inquire into those to see if public benefits would have in fact offset any disadvantage that poorness may have engendered to these parents. And also, of course, distance was an issue. They lived in Rochester. That made it a complicating factor with respect to bus tickets being wired, Greyhound tickets, tickets being mailed, Central tickets in Syracuse. There was some, at least hearsay, comments by the caseworkers that the parents had been in touch saying that we did not get those tickets. Of course, we don't know the truth of that, and that's part of the problem. There was no adversarial process, in effect, when the judge decided to proceed by default. And I would argue, Your Honors, that there was not significant harm to the child at this point. A short adjournment to figure out and try to get to the bottom of what was going on would not have hurt him. He was reportedly doing well with his pre-adoptive home. In fact, he was seeing his grandmother. All parties seemed to agree that this was something highly beneficial for the child.
But is this an instance where the hearing started and ended on the same day?
Yes, it is, Judge. Well, there was one adjournment. Let me backtrack. And that was an adjournment that was requested by the county, and it was requested because they attempted to lay the foundation for the Monroe County caseworkers' notes, but they had not called that necessary witness. And so the court found it proper in that case to adjourn for that matter. And I think that speaks somewhat to the lack of harm, or at least the court's perceived lack of harm towards the child here, at least when it came to the adjournment requested by the county. And I would also like to point out that it was not clear, and everyone seemed to express concern as to whether or not the grandmother would be able to continue with visitation rights with her grandson. Perhaps an adjournment would have been a time to figure that out, because everybody seemed to believe that this was something that the child needed, especially if we're talking about severing the parents' rights as well.
Counsel, you should begin to wrap up.
And with that, I would just briefly say that there was prejudice to Ms. Gorton. I think for obvious reasons, she didn't have a chance to defend this matter in court. And with that, I'll rest on my brief. And thank you, and I apologize for not being in the court.
Very good. Counsel, you want to restart?
Yes, Your Honor. Your Honors, may it please the court, I'm not going to rehash what I started. I was just, will spend the remaining time I have left.
Address this for me. The strength of his argument appears that two things, in my view. Number one is no harm to the child for the adjournment, number one. And number two is the court granted the county an adjournment when it wanted it in order to comply or comport with the procedure of getting evidence in. So why shouldn't that be a strong factor that we should look at?
Your Honor, as it relates to the first question as regards to harm to the child had been in care since 2017. Obviously, the trial court has to weigh what's in the best interest of the child in terms of establishing permanency. In this case, the first day of fact-finding was January 27th, 2020. So this kid has, Mr. Tyrone, I guess I should say, had already been in care for an extensive period of time. As it relates to your second point, can you re-ask what the second point was?
They were trying to put documents in from the Monroe County DSS, correct?
Correct,
And they didn't lay the proper foundation.
Correct.
And so you asked for an adjournment, and the court freely gave the adjournment.
Correct, Your Honor, and that was, and as stated in Family Court Act 1048, that they have to demonstrate good cause. In that case, there was technical issues in terms of admitting that evidence. However,
the point is, when you're talking about a fundamental right with respect to terminating parents' parental rights, why would the court so freely give it to the county but deny the parent an opportunity to be there?
well, Your Honor, not to, I guess, speculate into what the court's mind was when they made that decision. The court takes careful consideration of all relevant factors, as I believe one of the honors had put on the record. They were aware of Ms. Gorton's inconsistent history, as well as at the time that a request of adjournment was made by Ms. Gorton's attorney, he basically said that he had no reason why he was requesting for the adjournment. He just knew that she wasn't present that day. And as this court has previously held, a vague statement as to why they're not here is not grounds to show good cause for an adjournment. And not only that, I mean, an adjournment was granted, and as to February 21st, 2020, and Ms. Gorton still failed to appear. So, I mean, there was just another opportunity for that. With that being said, if the court has no more questions, I would rest on my brief. If you'd like, I can provide an update on how the child is doing.
That would be fine, please.
Tyrone is doing well. He is still in the same pre-adoptive foster home. He is in 8th grade, and I believe, he is very athletic. He participates in soccer and basketball, and he also did swimming at one point. I believe it was last year, but those seem to be his favorite sports, and he's doing very well in school.
Thank you.
Thank you.
Case 889, Davis versus Town Board of Town of Villanova.
Good morning, Your Honors. Richard Lippis for the petitioners. There was only 2 issues in this case.
Counsel, let me start out with just a procedural one. Why, I understand you have a hard time. I'll try to be a little louder. Why isn't this case moot?
Why what?
Isn't this case moot?
Counsel, before we go forward,
well,
I'm sorry to interrupt my colleague here. Do you need some assistance with hearing? Because we do have hearing aids.
I have hearing aids, but they're new, so I'm getting used to it.
We also have some technology here that might be helpful to you if we want to try.
I've used it before, but these work better.
Okay, all right. So we'll keep our voices up. You keep your voice up, and we'll see how we get through this.
That would help,
My
yes, thank
apologies,
you.
Judge Satchel.
Okay, the mootness issue is based exclusively on the McGraw case, which was a previous case dealing with similar issues. We call it Villanova 1, and this one Villanova 2. In that case, in the McGraw case, originally the trial court, in fact, granted our petition, so we were successful. And the respondents appealed. We did not cross-appeal because we were successful.
No, but you could have cross-appealed.
Yeah, and
But
one
Counselor,
of the
you
issues.
could have cross-appealed.
Pardon me?
You could have cross-appealed.
I could have cross-appealed.
Yes, you could have, because the court
Yeah.
didn't rule on the issue, other issues, and those are considered denied, and as a result of denial, you have, at that point, when they appealed, you could have cross-appealed for an alternative determination by the court.
Yeah, that's correct, but in 50 years, I've never cross-appealed where I won. Maybe it was a mistake, maybe it wasn't.
But the point being, that when we reversed it, and based upon the language of the town board that said if the town prevailed on appeal in 2018 proceeding before this court, the resolution would be deemed rescinded, and the 2018 determination with respect to the project will be in full force and effect.
Yes.
So now we're going back to the 2018. That ship has come and sailed. So what is left for us to look at?
This 2019 case was a new case, a new proceeding, under new facts as it related to both what the trial court indicated in its decision and the issue of the conflict of interest was specifically discussed in the second decision where it wasn't in the first decision.
Correct, I'm going back, the conflict of interest that was never discussed in the first case, 2018.
That's correct.
Was deemed, your motion was denied, you didn't appeal from that denial. So, like I said, that issue has been determined by this, has already been determined.
That's correct.
And so it's not appealable.
That's right, and this court determined it wasn't before you. I understand that.
But it's the law of the case. I mean, the court ruled and there's been no appeal from that. So your time to appeal the 2018 conflict of interest issue that you have before us today, okay, has been gone.
It can be if it's a new proceeding, which this is. If it was the same, if it was 2018, the proceeding in 2018, the rule of the case would apply. But now we have a new proceeding, a new vote in 2019, and we have a new decision from the court.
Okay, so, but once again, it's, the 2018 has been rescinded. The 2019 has been rescinded, correct?
The what?
The 2019 board determination has been rescinded, correct?
The two, I think you mean the...
2019 has been
yeah.
rescinded. So if it's been rescinded, the issues regarding what took place there are no more in existence. We're stuck with 2018.
Well, if you're going to go back to 2018, then it seems to me we have the right now to raise that issue of the conflict of interest before this court. This court has never considered the conflict of interest.
Correct.
And
why didn't we consider it?
Pardon me?
Why didn't we consider it?
Well, now you've gone...
No, why didn't we consider it back then?
First of all, I'm not so sure that a legislature can pass a law contingent upon some other matter.
Okay, so let me just give you, and I'll leave you alone here, just as a practical standpoint. Assuming we rescind the 2019, assuming you're correct, it's before us, there's a conflict, there's this, we rescind it. That disappears, correct?
Yes.
What's left?
The conflict was still...
No, it goes back to 2018, and 2018 is the law at the present time. So even though it's a hollow win if you win on the 2019, because then 2018 becomes the law. And if we did away with this rescinding theory.
If in fact that's legal, that they can in fact...
Well, I'm saying to you, assuming it's not legal, assuming 2019 is before us,
Okay.
correct? Assuming we find you're correct and we throw 2019 out, what's left on the books down below?
Then you have a new proceeding.
No, we have 2018 that's in full force and effect because we ruled on it already, saying there was a valid SECRA and there was
Yes,
no other
but-
issues before us.
But you just said assume that I'm correct,
On the 2019.
that in 2019...
So 2019 goes away, correct?
No, I'm assuming that 2019 does not go away, because I'm assuming that a legislature cannot pass a law contingent on an extraneous
Okay.
matter.
I'm done.
And I also would submit that, given the circumstances of this case, that even if they're correct in rescinding and being able to rescind the law contingent upon some other extraneous event, we are before you now with a new appeal, and we should have the right to challenge the conflict of interest that was not before the court previously. And assuming that we're correct, there's no question that Nathan Palmer had a conflict of interest. He eventually, belatedly, in fact, affirmed that when he made his disclosure. Now, the only question then would be before the court is whether or not that disclosure and that conflict would require him to recuse himself in the vote. Now, this is an important public policy issue as to when a legislature or municipal board member has the right to affirm that he has a conflict of interest. And in this case, there's, there's a financial interest in his entire family other than his direct family or direct interest. And he served two
Did he have a
masters.
financial, did his immediate family have a financial interest? In other words, wife and children, did they have a financial interest?
No, his mother-in-law, father-in-law.
And is that enough?
Brother-in-law and sister.
Is that close enough in relationship to have it take effect, the conflict to take effect?
It wasn't his wife or his children that had the financial, and he didn't have a financial interest. And the court indicated below that he personally had to have a financial interest in order for him to be required to recuse himself. And based on 809 and based on common law conflict of interest, as indicated by McQuillan, for example, if there's even an appearance of impropriety or a potential conflict of interest, the legislature should recuse themselves. That was not done here. And if
So your argument is it's an appearance of an impropriety because relatives beyond his immediate household had an interest.
That's right. If you say that there's no pressure on him because they weren't his direct relatives, I'd like to sit at the dinner table and listen to the conversation between his relatives and him if he voted against. I mean, clearly the financial interest of not just one, but 4 of his family members had to have entered into his thinking.
Counsel, we have that argument. You should begin to wrap up.
Thank you, Your Honor.
Thank you, Counsel.
May it please the court, Charles Malcolm for the respondent, Ball Hill Wind Energy. I'd like to just kind of center in on Justice Centra's questions with respect to the mootness issue because I think that kind of keys in on the disposition of the entire matter. Right now in Chautauqua County, there's a wind project under construction pursuant to approvals that were issued in 2018 and which were upheld and reinstated by this court in the McGraw case, which are not at issue in this litigation. This case challenges approvals that were issued in 2019, which were for the sole purpose of responding to a decision at the trial court level in McGraw that were never necessary because of this court's ruling in McGraw. So I think that's well understood. But Justice Centra, I think your point with the question was that even if the approvals didn't automatically terminate upon the occurrence, what happens if the petitioners are successful in this appeal? And the answer is nothing, because if the 2019 approvals are in place now and are invalidated, the 2018 approvals, which are not at issue in this litigation because they have not been challenged, will not be affected. So that's the definition of a moot case. The rights of the parties will not be affected, the interest of the parties will not be affected. And so this really becomes an academic question as to whether or not there's a conflict of interest on a decision that's, essentially been rescinded, but whether it's not, and that's by definition academic. And I don't think there could be a more moot case. With respect to the merits, or lack thereof, on the conflict of interest case claim, First of all, we're now just hearing about this common law conflict and the appearance of impropriety. That's not what they pleaded in their petition. They pleaded a violation of the general municipal law. That's a very specific type of conflict. And what they argued was...
Does that provision of the general municipal law apply to non-immediate family members?
No. Oh, well, two things. First of all, General Municipal Law 809, which is a disclosure requirement, not a conflict provision, okay? General Municipal Law 809 provides for certain disclosures for applicants for land use applications. And that does apply in circumstances that are broader than immediate family, and that was complied with here. It's undisputed in the record. Record 86 was the disclosure statement. The conflict prohibitions in Section 801 applies only to immediate family. And it's undisputed that, as Mr. Lippis just admitted, that the interests here have nothing to do with immediate family members, they're in-laws. So under what they pleaded in their petition, violation of General Municipal Law Article 18, there is no conflict as a matter of law. And I would also note this appearance of impropriety argument. There's no conflict, there's no prohibited conflict under that standard either. I would refer this court to the Friedhaber case, which was affirmed by this court. Very similar circumstances. It was a wind project where similar circumstances, in-laws, project opponents argued that the project should be invalidated on that basis, and we would refer the court to that case. And if there are no further questions, I would refer the court to my brief. Thank you.
Good morning, Your Honors. May it please the Court, Colin Knorr for the respondent, Town Board of the Town of Villanova. In the interest of Your Honor's time, I believe these matters have been well addressed by the other respondent. There was no issue with GML here for the town. It complied with the statutory requirements. It complied even to the extent that there would be a suggestive impropriety. As counsel noted, the Friedhaber case is really on point here to what that needs to rise to. Unless Your Honor has any further questions, the town would rest.
Thank you, counsel.
Thank you.
Case 890, Michelle H. versus Buffalo Edge, LLC. Proceed, counsel.
Thank you. May it please the court, counsel. John Ferlito for Michelle H. and infant AJ. This case involves the installation of a hot water heater on Spranger Avenue in Buffalo, New York. Just a couple of things, just before I get started. Hot water, cold water is sent into a home, such as a residential property. From there, some of it is diverted to a hot water heater. Hot water is heated there. Combustible gases go out of fluids, such as carbon monoxide. Some of the hot water must be very hot for sanitary purposes, such as a dishwasher, possibly a kitchen sink, and a washer and dryer. Other water must be modulated. It must be moderated by the mix of cold and hot water, and that's done by the use of...
But here, the question before the court was on summary judgment, correct?
Correct, Your Honor.
And with respect to how the court ruled in dismissing, did the movants meet their initial burden?
No, sir. No, Your Honor. No, not at all.
And the burden is on the move-in, is
Mr.
that
Ferlito?
correct?
And I pointed out...
Mr. Ferlito, I'm going to ask you to move over in front because, you know, we want people to be able to see you. We're streaming live, so.
Okay.
We're not a jury. You don't need to pace up and down.
All right. Well, I'm a little upset about this case. Just to let me finish my sentence there. The thermal mixing valve mixes the cold and hot water, so So the water going to fixtures, and these are all defined in the maintenance code.
But counsel,
Fixtures.
nobody's denying there's no mixing valve here. They're
Right.
not denying that it says there should be,
Right.
based on the machine or in the installation instructions or in the owner's manual.
Right. Okay.
Okay, so
But they-
please get this.
The mixing valve shall be applied to fixtures such as bathroom fixtures. That's what,
Counsel,
I
we
think what you said.
understand, we don't put our skin in dishwashers, we don't put our skin in machine, to wash.
But you can't put it, you should be able to put your skin
We
in,
understand.
in a bathroom sink.
But more fundamentally, the question is procedurally, before the court was a motion for summary judgment. It wasn't a determination by a jury or by the trier of fact of the court in a non-jury trial.
Okay, the burden of proof on installation?
No, with respect to the motion.
All right.
Please listen.
I'm listening, Your Honor.
Here, did the court apply the right standard? Did
No.
they meet their initial burden?
Of course not, Your Honor.
And once they if they had met their burden, the burden would have shifted to you.
Of course, Your Honor.
Here, is there a question as to whether or not the court flipped it and put the burden on the plaintiff to put the burden on the plaintiff instead of the move-in?
Justice Furlong put a burden of absolutely proving beyond a doubt by an admission of the defendants that they didn't install this hot water heater. That's one way he shifted the burden. He shifted the burden on saying I couldn't prove that the water wasn't hot enough for the child to be burned.
And that's not the standard at the time the summary judgment
Of course
was
not,
made.
Your Honor. He made determinations that I would have to show that the hot water heater was at its lowest level, the thermostatic dial on the heater, for him to even consider
Well, counsel,
my expert.
it seemed to me, in reading through the record and reading the transcript of the argument in this case in particular, that when Justice Furlong came out for this argument, he had read through most, if not all, of the materials. He seemed very well up to speed on what was presented to him. But he seemed to shift right to you and not to the move-ins for summary judgment, and that is the defendants in this case. And he shifted to you, and I was a little troubled by some of the questions that involved, you're not, how do you prove this? And pointing to you and asking you on this motion how you would prove this. And that's not your burden, and I think that's in part what Justice Troutman's pointing out. But did in fact the record reveal that your client testified to the fact that it was on the lowest possible setting? It seemed that the judge was seizing upon that during the argument, and that he was saying, well, your client has already testified that it was on the lowest possible setting. And is that where is that proof enough for them to have carried their burden and shifted to you to demonstrate that it was not?
Well, that's a very good question. Actually, the tenant who was there said that at one point, she told the Section 8 individual that the water was too hot. And he told her at that time, at a remote time, during an inspection, that it was set at its lowest temperature. Now, no one ever said it was at its lowest temperature at the time that the infant was injured. Okay, but I believe he said it maybe 6 or 7 times that was something that he was really focusing on, which was hearsay upon hearsay, which was a finding of fact of his that he relied heavily on.
The fact that, in the record we have photos of the injury here, which are very dramatic, it would seem clear that at the time that the injuries occurred, that it was clearly not at the lowest possible setting.
Your Honor, the Buffalo Police, an officer by the name of Adam Stepney, went in either the next day or the second day, measured the temperature. It was at 148 degrees Fahrenheit. In the instruction manual, it says that 150 degree temperatures can cause third-degree burns in 1 to 1.5 seconds.
Counsel, there's no dispute, though. I didn't understand that defendants are arguing the child wasn't burned by the hot water coming out of the sink in the bathroom. Is that an issue as to what caused the burn?
Judge Furlong went beyond the defendant's position. and said that he couldn't make that determination. They didn't decide that. But at 150 degrees, 148 degrees, a little infant is burned in a second or a second and a half. This is a defect in the plumbing, and our expert lays it out very well, that since the 1970s, this has been a known hazard, that there are industry regulations that indicate it. It's plastered right on the front of this hot water heater, and every hot water heater sold in the United States. This is a sophisticated commercial real estate operator. This isn't like a naive homeowner.
But again, the question goes back to, at a summary judgment motion, let's say for the sake of argument, defendants did meet their initial burden. Your argument is there are multiple issues of fact that require the case to go before a trier of fact.
Yes, Your Honor. I'll go one step beyond that, though. There are multiple questions of fact where it should have gone, where it should go to a trier of fact, a jury. But I submit that our motion for summary judgment, we've showed that it was not, that the instruction manual was not followed. They tried to save on $100 or less piece of equipment, which should have been there, that the injury warned of occurred, and the injury.
So you say there's no question of fact as to who installed or how it was installed?
Judge, can I respond to that question? They denied it. Then they said, well, they didn't remember. It was Louis Sirianni, a plumber. We deposed him. Mr. Sirianni said, it wasn't me, it was probably them, because he tries to save money on labor-intensive things by having his own men do it. Okay? So then we asked for their submissions, their payments, their invoices to a plumber. There were none. When confronted with this, the owner of all the LLCs, Matthew Reed, says, well, maybe it was our guy, but based on the records. The bookkeeper, secretary said, well, it must have been our guys because there's no proof. Judge Furlong still refused all of that proof. We went to the city to look for a permit. You have to have a licensed plumber to put in a hot water heater. And the licensed plumber has to have a permit. There's no record of any licensed plumber. I think it was beyond any question that there was proof that it was his folks that did it.
So counsel, you're asking us to reverse the grant of summary judgment to the defendants, but you're also asking us to grant you summary judgment? Doesn't the fact that you're arguing there's factual questions about why they shouldn't get summary judgment, that it sort of implies there's factual issues about you getting summary judgment?
I don't think they've met their burden, Your Honor. It was a very short term of words. But I think we've met our burden in showing that there was a defect. It was created by his men. There was a known hazard, and that if they didn't put that, if they would have put that in, this injury would have never occurred. And it's my position that there was negligence which caused this injury.
You should wrap up, counsel.
Thank you, Your Honor. Thank you very much.
Counsel? Counsel? Please have a seat up here. Up at counsel's table, please. We have certain traditions and rules here.
Good morning, Joe Eminger on behalf of Buffalo Edge LLC. I want to discuss Justice Troutman's question about the threshold question of burden. As it pertains to Buffalo Edge, there's no question Buffalo Edge met its burden on summary judgment. It did not install the hot water tank. Now, Mr. Farolito said
Who did?
It was either a plumber or an employee of BNYP Maintenance. It's very specific. Everybody said a plumber or the maintenance company. Nobody said Buffalo Edge, and the reason for that is simple. Buffalo Edge's sole purpose of existence was to own that property. And then it hired BNYP Properties to maintain the property, who then hired whomever it needed to, the management company, whomever. So I believe on the issue of installation, it's clear it was not Buffalo Edge. It's also clear, based on the testimony from the employees of the maintenance company and the tenant and her son, that no complaints were ever made about the hot water to Buffalo Edge. And that's very important here. We didn't create it. We didn't have notice.
What about the relationship between the entities?
They're all very separate entities for very specific purposes.
Are there all separate people involved?
Well, with respect to Buffalo Edge, I just want to make sure I'm talking about Buffalo Edge here. They don't share any employees with the other companies. They don't share an office space, a telephone number, and it carries its own insurance. So with respect to Buffalo Edge, I don't think there's any question it's a separate entity.
So
from the
there
other
are
two.
employees of Buffalo Edge?
There are not. I believe it is just Mr. Wright's, and that's it. The employees are either of the maintenance company or the property management company.
And Mr. Wright's is a common denominator as to all entities.
Yes, and I don't think that's unusual by any means. Mr. Wright testified he spoke to a lawyer. The lawyer told him to set it up this
Counsel,
way.
you're not arguing, though, that the water was hot enough to cause the burns that are visible and resulted in this child being treated at the Shriners Burn Center
No,
for weeks?
I think it's fair that the water probably caused the burns, but I think we have to point out there was an inspection done by the police department a day or two later. It doesn't say anywhere in the report what the setting was on the hot water tank.
Well, counsel, even if the setting at that day was at the lowest spot on the dial,
Sure.
they still tested it at 148, and you're not arguing that this child's hands weren't burned by the water from the bathroom sink.
No, Judge.
So who cares what the dial says?
Right, I'm not arguing that the burns were not caused by the water. I'm simply arguing that Buffalo Edge did not create the
But
condition.
didn't the judge say, how can I tell if the water was hot enough to cause the burns, since nobody can tell me what the dial was set at? And they kept saying wrongfully that the tenant testified it was at the lowest setting. If it was at the lowest setting and issued 148 degrees, then it's a defective hot water heater, obviously.
Yes, and Your Honor, though, I think it's important, though, to point out that there's no testimony, evidence, documentation otherwise that Buffalo Edge had anything to do with that hot water tank.
That's your argument. Your argument
Yeah.
is simply assuming for this argument that there's defective, the child was burned, the burns were caused, all those things that would create liability for some individual. It really doesn't matter to you who it is because it's not you.
That's right, Justice
And that's all you're
Centra.
really saying here is that no employees, you didn't share an office, did you share a bank account?
No, Your Honor. And there's some paper documents in the record that show which employees were paid by which bank account. Importantly, none of them were out of the Buffalo Edge bank account.
So that's as simple as that.
Yeah.
Whatever Judge Niemeyer is saying, you just should agree with because it has nothing to do with you.
Right, I would also just point out, we argue in our papers, we're an out-of-possession landlord, we're not responsible for the conditions on the property, and unless there's any more questions, I'll rest.
Thank you, Counsel.
Thank you.
Morning, Your Honors. May it please the Court. Eric Dolan on behalf of BNYP Maintenance. My client is the maintenance company, and I think it's important to note at the outset the limited role that the maintenance company had in regards to the properties that were managed by BNYP Properties and owned by Buffalo Edge. They had no ongoing duty to inspect any of the fixtures on the properties. They had no duty to maintain on an ongoing basis the fixtures on the properties in particular.
Who did have that duty?
I believe that the property management company would have had, to the extent that duty existed, it would be the property management company. The testimony was very clear from both the witnesses from BNYP Property and the maintenance workers that were employed by BNYP Maintenance that their role was limited to performing repairs that they were notified of by the property management company.
Did your company install the hot water tank? Did the maintenance, whatever the initials are, BMYP Maintenance, did they
Right.
install the hot water tank?
So the maintenance workers who testified, who were employed by the maintenance company, denied that they installed the hot water heater.
But the office manager thought it would be your company or people working for your company, did she not?
Or an outside plumber.
But the records show there was no outside plumber that got paid or no permit. And she said, most likely, probably, your employees.
The office worker did testify in that nature, Judge Nemoyer, but I think.
So doesn't that raise a factual question denying you the right to summary judgment?
I think if you look at the nature and the quality of the evidence and the testimony on the issue of who installed the hot water tank.
Isn't that a jury's job?
Well, It is if the nature and quality of the evidence is high enough to crest the threshold to even get to a jury. And I think in this case, given the testimony of the folks involved, it's so equivocal that a jury would have no facts upon which to draw a conclusion one way or the other. And in that
The court will
situation,
charge the jury, you can't speculate, but doesn't it get to a jury?
I think, again, it's our position that the nature and quality of that evidence is not sufficient to
We
get
have
to a
that
jury.
argument,
But
counsel.
leaving that aside, I think even if the court were to conclude that there were an issue of fact as to whether or not BNYP Maintenance was responsible for the installation, there were no facts developed in this record that it was BNYP Maintenance's decision or duty to pass upon whether or not the mixing valve that the plaintiffs are relying on needed to be part of this system. The testimony is unequivocal that the maintenance company's role was very limited to doing what they were asked to do. They certainly were not designed or responsible for designing the hot water system for this property. And there is no testimony or evidence that the actual hot water heater was installed incorrectly. So leaving aside that initial issue about whether there's an issue of fact regarding whether BNYP Maintenance actually installed it, there's no evidence to conclude that if they did install it, that they did so incorrectly or negligently. And I think
It seems, I mean, maybe you can clarify this, and I don't want to belabor this too much longer, but it seems that if they, in fact, a jury were allowed to determine who installed it and concluded that it was the maintenance company that did that, and in fact, they then did install it, wouldn't they have a responsibility to make sure that at the end of the installation, that there wasn't incredibly hot water coming out of a sink faucet, or a tub faucet for that matter?
I think on the evidence we have here, there's certainly strong circumstantial evidence to suggest that that was not the case. We had the Section 8 inspectors coming through on a regular basis. There was no notation in any of those inspection reports about water that was certainly hot to this degree. And I think this gets back to...
Was there a detail in the record that maybe I missed that the Section 8 inspection took into consideration the specific determination as to whether the temperature of the water coming out of the sinks, was that part of the Section 8 inspection? And is it in the record somewhere? Could you point it out to me if it is?
It's not listed as something they specifically tested in the actual reports from Section 8, but I think there was some testimony that as part of their inspection process, they would test all of the fixtures.
To see if hot water came out of it, but they never tested temperatures and didn't feel it was necessary under Section 8 housing.
Right. I think that testimony, you're correct, is probably equivocal. But I would like to point out, and this kind of goes back to your point, Justice Nemoyer, about the nature of the injuries and the fact that there's really no dispute that at the time of the injury there was hot water to an extreme degree coming out of that faucet. I don't think we're dealing with a res ipsa loquitur case here. The tenants in that building had access to this hot water heater at every point after it was installed.
And both the tenant and her 16-year-old son at their deposition said, we never touched the dial.
Correct, but the fact remains that that unit in the basement is open to the other tenant in the building and
So then
folks who
wouldn't
could be
that
in the
not, in the
residence.
very least, create a question of fact?
Again, when you're talking about the maintenance company in particular, the movie really does end at the installation
Not
of
if they
the
didn't
device.
properly install it.
Well, for purposes of what they did, exactly, for purposes of answering that question, if you have...
If there's a question as to whether their installation, as opposed to someone subsequently doing something, you have a question of fact that arguably may not necessarily allow them out of the case.
Right. My point's a little more narrow than that. I think the fact that there was an injury subsequent to the installation is not sufficiently probative of whether there was a mistake in the installation where you have other factors, including device malfunction or folks in the building adjusting those settings.
That is the issue. There are multiple questions that you're throwing out as to whether once it was installed, you were done and over, or whether some subsequent intervening force was in fact responsible. But in any event, you claim that you were entitled to that which the court granted.
Correct, Judge, and again, I would ask the court to look at the limited nature of the maintenance company's involvement in this.
We'll take a look at that, counsel. Is there anything further?
No, Your Honor.
Thank you.
Good morning. May it please the court, this case has been discussed at considerable length. What I have here is BNYP Properties. We didn't install it. It was arranged to be installed. We don't own the property. So if you look at the particular entity here, I think we are entitled to summary judgment because of our limited role here with respect to the property. I do want to mention a couple of things, though, that have been kind of glossed over. Between the installation by the maintenance company, 17 months transpired where nobody complained, nobody got burned, and this is an unfortunate interest. Yes, Justice Nemoyer, there was a burn here. I suspect that if any of you go home tonight and in your home or wherever, turn on the hot water, don't blend it with the cold, but turn it on, you're going to burn yourself. I know I would. So you have to exercise some responsibility. Now, while the responsibility, I believe, under the applicable law and in the absence of an alter ego responsibility, which we discussed in our brief, I don't believe there is any basis for the imposition of liability against my entity, unless you simply say there was common ownership and everything is blurred. It shouldn't be blurred here. Whenever the installation occurred by the maintenance company, 17 months went by. Nobody in the building burned themselves. What happened that particular night? You say, Justice Troutman, that questions of fact arise. Well, I guess they would arise anytime anybody, anywhere burns themselves, and that's unfortunate. Other than that, I'll simply rely on the issues that I raised in my brief with respect to BNYP property.
Thank you, counsel. Case 892, Edwards versus Edwards.
Good morning, Your Honors. May it please the court, Clifford Eisenhut for the appellant Bruce Edwards. I've got a catalog here of about 9 distinct issues where I feel like the trial court really was mistaken here. And I accept, just to be clear, because this is a somewhat unusual procedural posture, where this divorce was settled with incorporation of these temporary orders, and there was this directive that the court would settle any disputes on the accounting for the sale of the farm proceeds. The first, and this one, and I apologize, I couldn't even address it in my original brief because it didn't come to my attention until I received counsel's respondent's brief, is the issue of these 2 affidavits. Well, it's an affidavit of Michael G. Cole's and counsel's affirmation. Those, I think, is just a clear due process issue. There's just simply no notice and opportunity to be heard. I think the record's pretty clear that those were served exclusively by email to an address that I requested judicial notice of Keith Eisenhut, who is trial counsel for Mr. Edwards. That's not his address. If you look at that supplemental record, that's not, simply not the address that was sent. We had no notice and opportunity to respond to those. Therefore, I couldn't address it in my appellant's brief. I did hit it in the reply brief. Next, we have the affidavits. We do have a replete, and I won't go into enormous detail with this, but the affidavits are, even if you accepted them, are replete with evidentiary problems. You've got hearsay problems throughout. You've got brash speculation.
Well, Counsel, let me try to short circuit this. You know, we've looked at the record. Part of it really boils down to the court's determination on the assets. And without any proof of the actual assets, the value, without any cross-examination, or without having an opportunity to cross-examine the court-appointed appraiser, review the appraisals, and the fact for our problem, I think we run into, at least my problem run into, is the fact that the court really doesn't articulate its reasons how it came to this ultimate credits for the wife and lack thereof. And so really, what you're ultimately asking us for is, based upon everything before us, that at least there should be a hearing regarding the credits, that the wife and the husband should have an opportunity for cross-examination and put in his proof. That's really the nub of it.
Absolutely. And there's this concept that the evidence has to be viewed in the light most favorable to the non-moving party. And we framed several issues of clear factual dispute. Mr. Edwards says, I took all those monies that you're talking about, not all the monies, because I understand there's some, and I get it, that couldn't be put in there, but most of the monies, cow sales, lumber sales, haylage and square bales, these monies were taken in, and he says in his affidavit, expended for the continued operation of this farm.
And that leads back to my thing.
Exactly.
Without a hearing,
Yeah.
none of this was vetted.
So you have to believe Mr. Edwards. You can't make a credibility determination on the papers. I'll move right along. That applies to the issue of the evaluation of separate property parcels. We want the opportunity to sit Mr. Coles in that witness chair and ask him about certain factors that he may not have taken account of. All we were stuck with on motion is Mr. Coles' affidavit. We can't cross-examine an affidavit.
That's what Justice Centra said,
Yep.
right? In other words, you can go through the list, but we've gone through the record.
Okay.
And there are a number of things that you would like to challenge at a hearing, make sure that the judge who ultimately rules has all the evidence before it that has been tested through
Yes.
cross-examination. And then, based upon that, that would develop the kind of record that we would need here that we don't have now.
That's absolutely correct.
I think we have your argument, Counsel.
I'll submit on the brief. Thank you.
Thank you.
May it please the court, Your Honors, John Brunizer for Heidi Edwards, the respondent. First of all, with regard to the value of separate property assets, they stipulated to that. It's clearly said in the judge's written decision of September 11, 2020, that they stipulated to the value of the 4 parcels of separate property that there were 4, and the value of those. They stipulated to that. There's no question about it. And what Mr. Edwards was requesting when he was talking about Mr. Coles, who he had stipulated to as being the exclusive agent for sale and who had valued all these properties, Mr. Edwards also signed the purchase offer that included all of these properties and assessed separate properties versus the others. So he was fully aware of it. And what he asked for was to have Mr.
Parties
Cole.
can sometimes stipulate to an appraiser, for example, but still reserve the right to challenge the findings and the values established by the appraiser, right?
But he didn't ask to challenge it. His specific language was he wanted Mr. Coles to explain and have the opportunity to value these properties. And that's exactly what Mr. Coles did, and the values were stipulated to. How do we get past a stipulation as to the 4 separate properties and their value of $232,000? Now, what the court ultimately did was through a process where Mr. Edwards had been asked over 8 to 9 months, provide your credits, provide what they are, provide the values of them. None were ever provided. In fact, the judge in his decision says, the credits I have on Exhibit 8 attached to my decision are the credits that have been produced. No others have, and therefore there is a lack of proof. This was on a motion. The only thing appealed from was that order of the judge. The judgment of divorce and the 4 orders made part of that judgment were never appealed from. So we had 2 issues. One was the accounting approved. They stipulated to the accounting. There was nothing wrong with the accounting itself. The only issue is they dispute how it was distributed, and yet they provided nothing, not one bit of evidence as to what their credits were. And to say that things like haylage and square bales were used to keep running the farm, well, at the time those haylage and square bales were sold for $30,000, it was under the control of Mr. Coles. It was never reported to Mr. Coles, and the $30,000 never ended up in the escrow account. There were marital cash surrender value of life insurance policies. We found out about one of them when it had to be paid out of the proceeds of the sale of one of the real properties, having never been disclosed. There ended up being 2 cash surrender values. One could not have been put in the escrow account because it still existed. It was in the account. It just hadn't been disclosed, but it was a marital asset. Mr. Edwards testified, well, I had augers.
Excuse me, counsel. How do you address the wrong email address?
Beg your pardon?
How do you address the wrong email?
That email never bounced back. We sent other emails to that address. And it's the same email that counsel uses, only with a different initial for the first name in the Eisenhut firm. It was never bounced back. It was there. But in any event, those 2, you could totally ignore my subsequent affirmation, I believe, and that of Mr. Coles, because Mr. Edwards never produced any credit. And the credits that we used were based on evidentiary matters, such as the tax returns, which showed that he had sold cows. The tax returns showed that he had lumber and timber developed. In fact, there was a motion about those early on because he had violated the automatic stay orders in doing those things. It was they were specific numbers to the penny. So our position is that there wasn't any basis to have a hearing. There wasn't any proof provided. All the appellant did was challenge how those proceeds were distributed and the credits that were in fact used.
Thank you, counsel.
Thank you, Your Honor.
Case 893, Legal Services for the Elderly versus Erie County.
Thank you.
Proceed, counsel.
Thank you. Good morning, Your Honors. Adam Ferrandino on behalf of the County of Erie. I think it's important to start here with what was alleged in plaintiff's complaint. The allegations in plaintiff's complaint are...
Well, we've read through the record, so you don't have to go through the allegations of plaintiff's complaint. Is it important that we take a look at the court's ruling in terms of the court granting the ability to amend the complaint? And the judge articulated the various reasons why he thought it was, well, I'm not sure what judge it was. I shouldn't say he so quickly.
Judge Furlong.
Judge Furlong.
Correct.
Why he thought that the complaint could potentially be amended in a way to correct any failings, right? And so to focus on just the complaint itself might lead us down the wrong track, don't you think?
Well, Your Honors,
And he indicated he would entertain motions against the amended complaint. In other words, any objections you would have to those, any legal objections or otherwise, you would be able to put before the court.
yes, Your Honor, but I think the important point here is there something here to amend? We have a single cause of action which does not have a medical malpractice component in it at all. It doesn't, notice pleadings are supposed to put the defendant on notice of the claims. There's nothing in there with regard to medical malpractice at all, nothing even remotely suggesting it. And the problem you have with regard to a defendant like the County of Erie, who is multifaceted, who provides all kinds of different services to all kinds of different people and has all different kinds of responsibilities, it doesn't put us on notice of it at all. And the problem, too, is the fact that
So it
it's
doesn't
nothing.
put you on notice that there was a person that provided services, a civilian, not a sheriff's deputy, that could have been a medical person? Is that what you're arguing?
There's nothing in here, Your Honor. The only thing that's pled is the fact that the Erie County Sheriff's Department, which we all know, and I won't go through it, is not the County of Erie. The Sheriff's Department is...
We're totally clear on that. So the reason for the request to amend, wasn't that due to discovery?
Except for the fact, Your Honor, well, there are two issues with regard to that. One, the fact is that the discovery, which was when it was finally conducted, was all conducted after the statute of limitations with regard would go over.
So you're saying that the plaintiff was supposed to know all of the facts to have put you on notice. All they knew at the time, arguably, if all they knew at the time is that the person was in custody and had an episode claiming that they needed some sort of assistance, that's not sufficient to put the county on notice that there's a claim that they weren't treated in the right way, and that perhaps there was someone related to the county involved?
Correct, Your Honor. It doesn't put the county on notice at all.
And your argument appears to be the vicarious aspect of it. The county's not vicarious.
Well-
The complaint really was crouched in the vicarious liability of the deputies regarding the county. I mean, that's, that, and I think the core point is this. Once an action's been instituted, discovery begins. And during discovery, it shook out that Mr. Donaldson was an employee of the county. I don't think from the beginning anybody had any idea that Mr. Donaldson was involved at all and at what stage he was involved in. And for that matter, when talking about medical malpractice, he was just the messenger. He never, the allegations are ultimately going to be here that he never forwarded on his letters and the complaints to the doctor, psychiatrist. And so therefore, the doctor, psychiatrist can't be medical malpractice because he never got it.
I think there's a couple of points there, Your Honor, if I could unfold it for a moment. The first thing is that the medical records, which the plaintiff had way back when, demonstrated the fact that he was evaluated. So we do know that the plaintiff knew that long ago. Number two, that as this court has pointed out, that the sheriff has a non-delegable duty to protect the safety and welfare
Counsel,
of those.
Can we go back to your first point? You said that plaintiff knew about Donaldson early on. I think you're specifically saying back in 2016. And are you saying that that's after the deposition of Donaldson? Or they just knew of a record discovery and they later found out more specifics with respect to the depositions of Donaldson?
and it's clear in the record, the plaintiff's counsel had the letters even before this all started because of being the deacon at the church and the whole scenario, number one. Number two, in our responsive pleadings, in our answer, we raised all the affirmative defenses that it wasn't us, that, the wrong parties, and plaintiff's counsel did nothing. They did nothing until we got to 2019 at the earliest, which is well after the statute of limitations is gone.
So, as I understand, Judge Furlong was leaving it for another day to determine if, A, it should be pled, or whether, and that the plaintiff would be heard as to whether an amended complaint should go forward. But in this particular instance, if the person who was supposed to convey the information, that is, this person needed some sort of care, but it's not a medical provider, but is an employee of the county, isn't that notice sufficient?
No, I don't think so, Your Honor, and for a couple of reasons. One, with regard to this issue with regard to the notes and when the Erie County person would have received them, we know that the person or the entity who's responsible for moving that mail back and forth within the facility, it's not the County of Erie, it's the Sheriff's Department. So But the person who was later identified, you're saying that's not your employee? No, the person later on was our employee. The question is, one, he was evaluated, number one, by that person several days before this incident occurred, and he was determined not to be a threat.
And are you saying that that person, in order to capture that person, the plaintiff was required to timely give notice of medical malpractice?
If that's what the plaintiff is claiming, then yes, the plaintiff is required to give proper and timely notice with regard to what those claims are. And in this case, they didn't do it. So, and on top of that, with regard to a malpractice case, I'd point out the Loesch versus the city of Syracuse, where that the municipality can't be held vicariously liable for the actions of the medical professional, where the medical professional was never sued in the first place.
And that's really, your argument in your brief is focused right on the vicarious liability issue.
Correct.
Yeah, and you're saying we shouldn't look to the employment relationship of Donaldson to your client. That's not important, because they knew about it, and if they wanted to sue based upon that relationship, they should have done it earlier, and they didn't, and that ship has sailed. That's your argument, right?
Yes, Your Honor.
Thank you, Counsel.
And with respect to the remainder, then I'll rest on my paper.
Very good.
Thank you.
Counsel. May it please the court, Roland Cerconi on behalf of the plaintiff respondent. Your Honor, first of all, we didn't know about a Donaldson. There was one notation, one letter that said, my client said, let me see Ernest. I don't know who Ernest is. I don't know who Ernest worked for. It's important to remember, when this happened, I have a brain-dead client that I could not speak to, and we don't know the internal workings of the Sheriff's Department. All we had in our hands basically were requests for help, requests for medicine, and letters that he wrote that I can't take it anymore, I'm going to commit suicide. And they came to us, weeks after he committed suicide. That's all we had. And one of the things was, I need to see Ernest. We don't know who Ernest is. We don't know who Ernest is employed by. At the time, we thought this was sheriff deputies not taking his letters for help and request and not giving them to the proper parties. However, we sued both the Sheriff's Department and the County of Erie. And in our initial bill of particulars, we did allege that the negligence constituted failing to properly give medical treatment and or medicines to the plaintiff and or treat or listen to his complaints of pain and discomfort, all leading up to his suicide attempt, and failing to keep under a proper watch. That was in our initial bill of particulars. Again, we don't know how these things came about, and we were trying to use the best with what we had. And we said they had actual notice of these problems by having the letters. Well, during the course of discovery, we found out there's 2 sets of employees in the holding center. One is the sheriff's department and one the county of Erie. Well, these letters for help apparently go to a clinician. And again, we don't know what medical expertise. That's Donaldson? That's Donaldson. I didn't know it was Ernest Donaldson. We had no idea who Ernest was until we did discovery. There was nothing in the records to tell us who Ernest was employed by or who Ernest was. And so we find out this Donaldson kept these apparently on his desk, maybe didn't give them to a psychiatrist. We don't know what, if anything, a psychiatrist is seen at this time. And so in making our motion and moving to amend, the court has allowed that. They did not oppose that in their brief. They did not oppose the court allowing us to amend our complaint to conform to the evidence. And so
But
that
isn't
was,
it left for a later date to determine that very issue?
exactly, and I submitted in my brief, his arguments are premature because the court is going to address these arguments and address medical malpractice and the issues of it. The only thing he addresses, he says this is respondent superior, and we're trying to ask that the sheriff's department be held liable for county employees, and we're not doing that. We're asking that the county be held liable for their own employees, as Justice Furlong addressed clearly in his I decision. think we have that argument, counsel.
Thank you, Your Honor.
Thank you. Case 894-895, Jones Memorial Hospital versus Main Street America Assurance Company.
May it please the court.
Well, let's wait, Mr.
Oh, I'm
Cohen,
sorry.
if you wouldn't mind, just for a
I'm terribly
second. We'll
sorry.
get all organized here and allow your
I was so
opponent
anxious to speak to you.
Yeah.
Sorry about
Well, your time has now come. Please proceed.
Thank you, Your Honor. May it please the court, Dan Cohen on behalf of the appellant. The facts are clear. We have a woman who fell, tripped and fell on a walkway as she approached the entrance to Dr. Cass's office. She had an injury, and she sued the building owner, us, Jones Memorial Hospital, and she sued the tenant. The lease required the tenant to provide coverage to the landlord, the Jones Memorial Hospital, for not only the premises that was inside the building, but for the walkway and the entranceway specifically. That's on page 75 of the record. They provided that coverage. And the injury occurred as this woman was entering the building for the purpose of seeing the doctor. So there's no question, from my perspective, that, and the court below so found, that Jones Memorial Hospital qualifies as an additional insured under the policy. So the issue becomes primacy of coverage. 15 years ago next month, I stood at this very same podium. That's the disadvantage of getting old, maybe the advantage. The same podium, and argued a case before this court, none of you were on the bench at the time, called Holliesville versus Travelers. Precisely the same facts, precisely the same language as we have in this case. We have a policy that provides that we are excess over any coverage where we are named as an additional insured by virtue of a tenant's policy.
And that's reference to the hospital's policy.
Yes, Your Honor.
And then the additional insurance, there is no such language in that policy as to excess versus.
Primary. That's right, Your Honor, and they have a primary policy. We have a policy that says we're excess over any other primary policy where we're listed as an additional insured. We're listed as an additional insured. Accordingly, we're excess.
And we're required to look at the language of the policy.
Your Honor, exactly right, and that's exactly what the court did, this court did in the Holliesville case. Same provision in our policy as we had in the policy in Holliesville, and the same result. The court found in that case that the additional insured language was the language that should be considered by the court. They considered it and found that the additional insured coverage was primary, and the policy that provided primary coverage to the landlord was excess. We asked for the same ruling, and I'd be happy to answer any questions
If not, I'll rest on my papers. Thank you, Counsel.
Thank you, Your Honor.
May it please the court, Matt Ronan for the defendant, Main Street America. Just the first point, before we get to the priority issue, whether there are additional insureds in the first place, what opposing counsel did not mention was the actual language in the policy, which, as you alluded to, you need to refer to. And the policy here only provides additional insured coverage with respect to that part of the premises leased to you. The premises, as defined by the contract, by the lease, is the 2,400 square feet in the building. We know this happened outside the building.
Doesn't it also say together with the right to use in common with other tenants, the common areas essentially?
Exactly, Your Honor, and that's the exact same kind of language we had in Pixley, not we, but you had in Pixley 2 years ago in 2019, which is controlling here.
Well, you see, here's the problem. I think that you've given Pixley too strict of a reading. I sat on Pixley, besides my other colleagues here, some of them. And we stated that that was just one of the grounds, in essence. And we went on further on Pixley to say that in our decision related to several grounds. Goes on, talks about the use of the driveway, the premise lease, store included, the delivery, the driveway. The store owner maintained it. That was when you're talking about had control. But there was other factors that we considered. And the way it was drafted, I can see you getting that control had to be a factor, but I think you've given Pixley too strictly of an interpretation.
Well, just one point on Pixley, Your Honor, which is that this court did not find coverage in Pixley. It only found a duty to defend, and it found a question of fact on the duty to indemnify. And the only question that was left unanswered was the control issue. So rhetorically, I'll ask, if the control issue wasn't dispositive, then how did the court get to a question of fact? It couldn't have. It should have found indemnity, but it did not. Moving on to the priority language issue, with all due respect, opposing counsel's argument is not relevant because it assumes that Section 2A of that other insurance provision in the MSA policy does not apply. However, you can't do that because the, misplaced it here, but the actual language itself says, business liability coverage is excess over, any other insurance that insures for direct physical loss. Now, plaintiffs assume that direct physical loss cannot mean liability, that it can only apply to a first-party claim. However, you can't strip the first half of the sentence from the second half of the sentence. It's one sentence. It's not a heading, as plaintiffs have argued in their papers. It's the first half of the same sentence, and you can't just strip it out and pretend it doesn't exist. And I'll answer any questions. Other than that, I will rest.
Thank you, Counsel.
Thank you.
Case 896-897, Feaster versus Mugina and Birangani. Counsel, first, my apologies if I mispronounced likely the names of your parties and clients.
I've met them several times and I couldn't have done anything.
Thank you. Please proceed.
Thank you, and may it please the court, Ron Wright on behalf of plaintiff, opposing counsel. Your Honors, I'll be brief. This is a case, motor vehicle accident case, 29 days later, the plaintiff executes a release for settlement of all claims for $1,000. At the time, as the evidence shows, the only injuries that were diagnosed or differential diagnosed were lumbar strain sprains. 6 months later, by a diagnostic imaging of the left shoulder and lumbar spine, the plaintiff ultimately finds out that...
Is it relevant that there were complaints with respect to the area that plaintiff later claims, or it is found that he does need the rotator surgery?
Sure, it's definitely relevant, the complaints, because in the end, in this court, adopting the framework from Mangini from the Court of Appeals, draws a distinction between actual knowledge of an injury and confusion as to the consequences or sequela of a known injury. We turn to the two cases that are right on point, Schroeder and Page,
Schroeder dealt with the same thing. Sprained strains diagnosed at the outset, later to learn by diagnostic imaging that there was tears and disc herniations. Same case here. We also look at Page where there was a hematoma.
But again, do you dispute that at the time of the signing, he was experiencing the shoulder problems?
I don't want to use the word problems. I will acknowledge that there was complaints, I believe, about the shoulder. But
Okay.
as far as, and the reason why I draw such a line there about between problems versus complaints is that goes to the utility of the diagnostic imaging.
Yeah, see, I view, maybe I read it wrong, but I thought it's a shoulder pain, but then.
Shoulder pain.
I mean, so
Yes.
the bottom line is this, you're arguing a mutual mistake. And
Correct.
so he was aware prior to the signing of the release that he had shoulder pain. He signs his full release, and then, and my understanding is insurance carrier or adjuster, whoever, didn't have any of these medical records. And so therefore, he settled the case for $1,000, and then you brought this application. Just to clear it up, it's my understanding that you made a motion to re-argue and the court denied it, but actually the court granted it because it gave the same ruling, but for different reasons.
Correct, yeah.
So you're properly here with the re-argument.
Yeah, I mean, the issue with the re-argument was a bit of having to prove a negative.
Yeah,
The court said,
but the court seemed to adhere to its prior ruling, but then articulated the reason for the denial. So,
Correct.
So we're here on a re-argument.
correct. And as to the adjuster not having the medical records, I'd submit even if the adjuster had the medical records, that still wouldn't be sufficient to deny our application. If you look at I believe it's the Schroeder case, the adjuster actually submitted an affidavit that said she was aware that there were sprained strains and that those could more likely than not be far worse in consequence. The court said, no, that's a tribal
So
issue.
you're saying that because neither side specifically knew everything, that the stipulation doesn't count?
Well, I do want to say that I don't think there's an obligation for them to know everything. I think there's a certain point where they have actual knowledge of the injury. And with respect to the injuries in dispute, the only way to have actual knowledge of those is diagnostic imaging.
So your position is your client was aware that he had shoulder pain, but not to the extent of the injury.
Correct, a sprain strain. And we're also significant with lumbar as well, right? He was diagnosed with lumbar strain, but we're talking the difference between a sprained strain and disc herniations requiring surgery and a rotator cuff tear requiring surgery.
I think we have that argument, Counsel.
Okay. And any other questions? Okay, thank you.
Thank you, Counsel.
May it please the court. And under these circumstances, there should be a minimum foundational requirement of an affidavit from the plaintiff himself that said, I didn't understand what I was signing. We don't have that here. As a minimum foundational requirement, he should have returned the check. We don't have that here. In this particular case, we have known injuries, maybe not to the extent, but that would be a unilateral mistake. And, pursuant to the EGW temporaries case, under these circumstances, the proof has to be clear and convincing evidence. By leaving out an affidavit from the person that actually might have made the mistake, that falls far below clear and convincing evidence. In this particular case, we have known injuries. He had the ability to navigate and negotiate on his own the property damage settlement. He could
Which was for what, counsel, about $5,000?
That was around $5,000, yep. But the only person that seems to have been taken aback by this is plaintiff's attorney. The client apparently is well aware of what his own body was happening. But again, we don't have any of that. As far as the nature of
So you're saying there's no requirement that there have been a definitive diagnosis?
There doesn't, and in many cases, there isn't. I mean, otherwise, we would be held hostage to any plaintiff who just never goes and gets an MRI. Or a doctor who says, I don't think we're at the point where we need an MRI, let's try physical therapy. And if that doesn't work, now we're way down the line and we get an MRI. We can't be held hostage to that. If someone wants to make a deal, they can make the deal. In this particular case, we have explicit language in the release any and all known and unknown personal injuries. That was the exact same language that this court used, approved of.
But
in
here
the Brock
you're
case.
saying that the plaintiff, before he signed the release, knew he had shoulder pain.
He knew he had shoulder, yes, absolutely. He
And
knew,
therefore, we should recognize the release.
absolutely, yes.
I think we have the argument, counsel.
I'm sure you do. Thank you, Your
Thank
Honor.
Very good. Just a reminder again, make sure your masks are covering both your nose and your mouth. Thank you. Case 898, Security Plans, Inc. versus Harder Seacrest. Counsel, I had you as submitted.
Yes, I did talk to the clerk's office. They told me to ask you guys, it was a clerical error. Ms. Bowling, who was the attorney who signed the original brief off our firm, emails to her account went to that account presumably. So I'd be requesting a brief period to argue or at least answer any questions.
Counsel, the difficulty is you put your opponent at a disadvantage by showing up where your opponent has not necessarily prepared to have an opponent. And so I'm going to deny your request.
Okay, I'm going to stay right here, Doctor.
You may.
Thank you.
Your Honor, to be fair, before I begin, I would like to mention that I had spoken.
Before you begin, counsel, is your mask complete or is there an opening in the front?
It's two panels.
Two panels, it's not open. Okay.
It's open, but there's a panel behind it.
There is a panel behind it.
Yeah.
Okay, thank you, counsel. Excuse me, Mr. Doyle.
Oh, that's all right. Your Honor, I just was going to start by saying, to be honest, I had spoken to Mr. Lenahan, I believe 2 weeks ago, and was aware he was appearing for argument. So, to the extent
Well, if
that-
you're prepared to respond, then I will give him an opportunity to argue, and thank you for advising the court of that.
Thank you.
Thank you.
So I thank the court, and I thank Mr. Doyle, too. I'll be brief so as not to test my luck here. Just a couple points I want to bring up. This case has been well briefed, lengthy briefed. One thing that occurred to me this weekend as I was looking at this is that defendants themselves admit the security plans needed to prove two key elements of this claim, of this formula, the loss ratio component and the experience rate component. And the Western District in New York and the Second Circuit, respectively, found issues of fact as to both of those elements, meaning that both of those elements should have gotten to a jury. Both of those elements that we needed for recovery should have gotten to a jury for a jury to decide. But the problem is that...
And so below, did you establish that but for, if we accept your claim that there was malpractice, that your client would have ultimately prevailed?
So I think what we show, Justice Troutman, is that but for the actions of defendant, both of those key elements would have gotten to a jury. I quit guessing what juries are going to do a long time ago. But the way they handled it, their chosen path ensured that those two elements were severed from each other permanently and never to be reunited. And that's really the crux of the malpractice.
And you say the law is such that they should have known better than to take the course that they did?
Absolutely. Their actions were based on a misunderstanding of the final judgment rule in federal court. They based it on some mootness exception to the final judgment rule. The case, as the Second Circuit pointed out, was not moot at all. We've also pointed out in our briefs other options.
Did the court do as they had requested in their letter?
Yeah.
Did they specifically request what the court did? Amending versus dismissing, because I'm asking you to dismiss?
Yeah, I think the court did do that. I mean, you know, and notably, as counsel, it was defendant's job to make sure the court did what they wanted it to do. To the extent it could have been a more clearly worded letter, to the extent it could have had a conference with the court.
So any ambiguity, it's on them.
Absolutely.
And then you say there was another avenue that would have made sure that all of the elements that were required were able to later be put before a jury.
Correct. And again, there are several other avenues that would have at least kept these two elements together and put them in front of a jury. And they may not have been the most cost-effective mechanisms, but when you're dealing with a scenario like this, where you're risking absolutely walking away from recovery, they were by far the more reasonable
And
choice.
when the other side says, though, due to the complexity of the issue at hand, there are, at the very least, there's an issue of fact as to whether ultimately your client would have been able to satisfy all of those elements.
Well, I think the complexity issue is a little bit of a red herring. Yes, it's complex. Yes, it's not your ordinary procedural posture, but that's what our job as lawyers is, to figure those things out. And the Western District of New York and the Second Circuit certainly didn't find it that complex, because the Second Circuit especially told them exactly what they should have done. They should have done X, Y, Z instead of what they did. So again, can I stand here and say that we guarantee a jury would have ruled a certain way? No, but we can say with pretty good assurance that had they taken a different path, these two key elements, which they admit security plans needed, at least would have gotten to a jury for decision.
Very good. Counsel, I think we have your argument.
Thank you again, Your Honor.
Thank you.
May it please the court, Vince Doyle. I represent the defendant law firm and the individual attorneys. The plaintiff, SPI, originally moved for summary judgment before any depositions had been conducted and while there were discovery demands outstanding. And they moved for summary judgment without submitting an expert affidavit or any expert testimony on the appropriate standard of care for attorneys in this situation. The trial court properly denied plaintiff's motion, finding that it was premature because discovery was incomplete, and they did not meet their moving burden of demonstrating the appropriate standard of care in the absence of expert testimony. For those reasons, and for the additional reasons we've laid out in our brief, we believe the trial court properly denied plaintiff's motion for summary judgment. And unless there are questions on that, I'd like to use my time to argue our cross motion for summary judgment. On behalf of defendants, we cross move for summary judgment on the basis that the plaintiff could not prove the necessary element of causation. And Justice Troutman, your first question went exactly to that point. And I believe that the answer that Mr. Lenahan gave demonstrates the weakness and the failure of the plaintiff's case to sustain our summary judgment motion. He said that had we done something different, they would have gotten to a jury. That's not the burden in a legal malpractice case. The burden in a legal malpractice case is to demonstrate that but for some negligence on behalf of the defendants, you would have prevailed in the case, not gotten to a jury. So I think that that is exactly the case within the case that I know the court is so familiar with. The plaintiffs must prove that but for some negligence, the plaintiff would have prevailed in the underlying case. They didn't establish that in their summary judgment motion. They didn't respond to our summary judgment motion, and therefore I think it should be granted. Here that element is focused on what the plaintiff itself referred to in its brief as the procedural impasse that was faced in the underlying case. Briefly, the plaintiff brought two contract claims, what we would call in the state court causes of action, one for breach of contract, one for breach of the implied covenant of good faith. Within both claims, there were three distinct theories. We only have to talk about two of them. Those are the loss ratio and the experience refund issues. Both issues the plaintiff needed to prevail on in order to generate a positive damage figure, okay, just because of the math that was involved. The plaintiff needed to prevail on both. That's conceded by the plaintiff, by the district court, and by the circuit court. Everyone recognizes that. Everyone also recognizes that under New York law, proving damages is part of an element of a breach of contract claim. So if damages couldn't be proved, there was no claim that could be made.
And then there was a ruling by the district court, and counsel for plaintiff had to make a decision as to procedurally if they wanted it reviewed before the Second Circuit.
Exactly. The district court dismissed one of those two theories and said there were issues of fact as to the other. That left the plaintiff unable to prove its case, unable to prevail at trial, to prove damages and to prove its case. So they needed to find a way to appeal the dismissal of the one issue and to preserve the second issue. And they researched, they consulted with their client, they obtained their client's informed consent, and they consulted with opposing counsel. That's something that's been ignored by the court, and not this court, but by the district court and the circuit court. They consulted with opposing counsel and obtained opposing counsel's agreement to the method that was chosen. And they proceeded with a certain approach to inform the district court of the exact problem that was faced and to ask the district court to amend its decision to dismiss the case in its entirety. Now, SPI has not shown, I said that this all comes down to an issue of causation. SPI has not shown and cannot show that there is any alternative path to a successful appeal. The element of legal malpractice include the but-for. We submitted proof from an expert witness on our motion and from the defendant, one of the defendants, Mr. Bridges, that in their opinion, there was no alternative likely to succeed. The burden then shifted to the plaintiff to demonstrate that there was an alternative appellate process that was likely to succeed. And they did not do that. They argued three options. None of them, I'll point out, was supported by their expert witness, that they only submitted on reply to our motion. None of their three options was endorsed by their expert witness. It's simply an argument that they make in their brief. Their three options are, oh, you could have gone to trial. Couldn't have gone to trial. We couldn't prove damages. We couldn't prove our claim. A lawyer has an ethical duty not to go to trial in a case that he or she knows they can't prove the elements of. The client didn't want to go to trial. Mr. Bridges, one of the defendants, said that in his affidavit, that the client, after consultation with the client, they said, we don't want to go to trial on a claim we can't win. And in fact, there's an email that supports that. The record, page 377, Mr. O'Kipney's email, or pardon me, 311. Mr. O'Kipney's email indicates we're either going to appeal or give up, okay, precluding the option of going to trial. Their second option was a so-called Rule 54B, and that is a district court can direct entry of a final judgment as to one or more claim, but fewer than all of the claims. The Second Circuit has to accept that. Well, the Second Circuit made it clear in this case that those different theories I talked about, the experience rate refund and the loss ratio, are not claims. They are components of a claim. They are theories under the breach of contract and breach of implied duty. So there is no way that the court could have done that in this case. 54B is not an option. In a very similar case that we cited.
So you argue here that counsel acted as a responsible attorney in the area and made a strategic decision, and that despite, in any event, despite what plaintiff says, plaintiff hasn't met the elements necessary for legal malpractice.
Correct.
And with respect to causation in any event.
That's exactly it, Judge. And the other option is essentially what I would call a sort of interest of justice motion. That is only available when there is a controlling question of law. That's the 1292B. That was not available because this is not an issue of law. It's an issue of fact. Were there genuine issues of fact? That was the issue in the appeal. So the options that plaintiff has put out there in their argument, not supported by any expert proof, but only by their assertion in their motion papers and on their brief, those in fact are not viable options. And they are not meeting, they do not meet the plaintiff's burden to demonstrate that they would have succeeded, that they were likely to succeed on the appeal. And then, as pointed out during the oral argument today, Mr. Lenahan, they haven't said, haven't proven, haven't submitted evidence that they would have succeeded at the trial. They're simply talking about we would have gotten to a trial, and that's not the standard. The last thing I wanted to mention is if the court does not grant us summary judgment, does not reverse and grant us summary judgment, the trial court did dismiss 2 of our affirmative defenses. I think this is a very important issue in legal malpractice cases. We raised the 6th affirmative defense was ratification, that the client ratified the course of conduct, and the 11th was professional judgment, informed consent. That we used our judgment, we advised the client of that judgment. They were both dismissed under 3211B. That's a very liberal standard. We made all of the correct allegations in our affirmative defenses. We don't believe they should have been dismissed. The court dismissed them, grouping them together with other so-called comparative negligence defenses, and said that they were being dismissed because there was no evidence the plaintiff interfered with our work. That's not the standard for those defenses. And I think we do a lot of legal malpractice work. That is a very dangerous decision to be out there, that a defense of ratification or a defense of professional judgment, a lawyer is allowed to use his or her professional judgment, that those can be defeated if there is no proof that the plaintiff interfered with the lawyer's work. So we would ask that that be reversed as well. And with that, if there are no other questions, thank you, Your Honor.
Counsel. Case 899, Van Dam versus Curran. Thank you. I'm not sure what the request is. An extra chair? Yeah. Oh, for the last case? Yes. They want to, say that again. For the case that we just heard? Oh, for the last case. Oh, yeah, sure. Yeah, I'm sorry, yeah. Counsel, proceed.
May it please the court, Teresa Perry representing the defendant appellant Patrick Curran. Your Honors, this case checks every box. It consists of every single factor that justifies the vacating of the judgment of divorce and separation agreements. We have zero financial disclosure, either between the parties or on file with the court. We have no advice of counsel, no attorneys involved.
So below, there was the wife, the husband moved to vacate the judgment of divorce.
Exactly.
Did he also move or bring a plenary action with respect to the property settlement agreement?
Yes, Judge, I would submit that the motion involves both. The motion.
You're saying the motion does?
The motion under 5015 to vacate the judgment and set aside the separation agreements.
So you're saying there's no plenary action required because you've realized the judgment of divorce was not to merge, this property settlement agreement was not to merge with the judgment of divorce. So you agree you could set aside the divorce, but that agreement would survive separate and distinct.
I understand your point, Judge. I think, ordinarily a separation agreement's a binding contract that would exist on its own.
Not ordinarily, it is.
But in this case, Judge, with all due respect, this separation agreement is devoid of material terms. So even if the separation agreement, which divides the rakes and ladders between these parties, exists, we still have no answer as to the real property division, the debt division, spousal support.
I guess the question is this, is procedurally, how do you attack it? You got two different facets. You got a separate contract, and you got a matrimonial action. I think that's what my colleague is getting to. And it appears that potentially your motion is directed towards vacating the divorce, but can that vehicle be utilized also to attack a contract? That's where I think the procedural problem exists.
Right, I understand the issue, but I would submit that when the judgment of divorce is under attack in this motion, then we also were attacking the separation agreements as part of the motion. It's very clearly laid out. But even if this court finds that the separation agreements were not part of the action, part of the motion, those separation agreements can exist. The judgment of divorce should be reopened because no one's decided anything about real property, retirement, debts, any of the assets.
Well, we're talking about a one-year marriage here, aren't we?
We are, Judge.
And can't the parties just agree and say, look, for the 1 year we're together, it's not worth litigating any of those issues, which appears to be what they did, and they went their own way. You're saying they can't do it, and we now should strike the divorce?
No, Judge, I'm not saying that. I'm saying that parties can make their own agreement when they have exchanged financial disclosure, when that financial disclosure is before the court, filed with the court as
So you're telling me
required.
that can't be waived.
It cannot be waived. DRL 236 states the financial disclosure is mandatory.
In
And
cases where you're seeking support, or there's child support or others, you're saying that if you're asking nothing from your spouse, you have to disclose everything?
I'm saying that, and with all due respect, this court has said it. In Tuzzolino, in Gibson, in Dawson, this court has clearly held that the financial disclosure is a necessary element when we have a party seeking to vacate a judgment of divorce and/or open a separation agreement. And the results are one party walking away with all of the assets and one party walking away with just debt, that the court has to look at that and has to consider the financial disclosure. Here, there's not insufficient financial disclosure. There's zero. There's none between the parties, and there's none in the court's file. And we know that the assets are over $300,000. We only know that now that the case has been reopened. But we have value here, even with a one-year marriage. And this court has never held that the rules don't apply to one-year marriages, or that the rules don't apply to three-year marriages.
And the time to set aside the judgment of divorce, the timeliness of it here?
Well, Judge, there were 2 years that passed, and I think the affidavits lay out that the defendant thought he could go back for the barn. That was his main issue. That's the debt he's paying on. He built the barn, and he's torn down barns and moved them before.
But the point is, you realize you're asking us to undo a judgment of divorce that was granted in 2018, she filed,
Yes.
and judgment was entered, and it's now 2021. You essentially want us to make them remarried again.
Judge, I'm asking this court to set aside the terms of the judgment of divorce as they relate to enforcing a separation agreement. The parties don't want to get remarried, they don't want to be married, and this court before has sent back to the lower courts a judgment of divorce to determine the debts and assets, not to have the parties married. And in this case, in this court, the Dawes case, Dawes
And you're
versus
saying,
Dawes.
despite the time frame that
Yes.
went by, she had no right to rely upon that it was over and done with. 2 years had gone by.
2 years went by, and in Dawes, this court reopened a case that had 4 years go by because there was no ratification. The parties were just going their separate ways.
And what is it like this, a one-year marriage?
Yes, Judge, it was a one-year marriage. And that's all we know. We don't know what the parties accrued during that year. We don't know what debts they accrued. We don't know what assets they accrued because there is simply
And you're
no
saying,
disclosure.
simply stated, these parties didn't have any right in a short-term marriage, barely a year, to decide they didn't want to go through the tradition that we should set aside the judgment of divorce and somehow set aside a property settlement agreement, although there was no plenary action, and your client gets to have at it, start all over again.
I'm not saying that parties can't decide to do that. I'm saying, and this court has said, if the parties are going to do that, they have to have financial disclosure, and it has to be a fair agreement.
You know, I understand, but you know what the problem is? The problem is what's bothering me is that we're commingling all these different concepts. Okay, they're separate. First, we have the vacate. Has it been within a year? The answer is no. Has there been a reasonable excuse? Has there been a reason for the court to address it? I mean, you know, these are all legal concepts. I mean, it's separate than the plenary action, separate than the motion with the divorce. And I'm still baffled by the fact is that how do we get around 50-15? How do we get around how do we get around the 1 year aspect? It's been 2 years. What reasonable excuse did you put forth that you know, you're going back saying, well, the reasonable excuse is the fact he didn't know what he was doing, he didn't give financials. That has nothing to do with bringing the application. for the motion. How do we get around this 1 year? I don't care what we did in other cases, because every case is different on its face. Tell me how you met the standard.
Judge, the court has inherent in its powers the ability to vacate a judgment. We know that from this court's decision in Telly versus Telly. We know that from the Court of Appeals.
But there's a reason why we do it. We understand what our power is, and I appreciate you understand that. But we're going back once again to something very simple, okay? We look at time frame that left. What is the reasonable excuse? We just don't say, you know what, they brought a motion, let's just grant it because we got this inherent power. Been here 15 years, I've never done it, okay? There's a reason for it. And
Right.
I'm asking you, what's the reasonable excuse of waiting 2 years?
Right, and so you'll know from the defendant's affidavits, he didn't know there was a problem. He shows up in June or July of 2020 to retrieve his barn. And at that point, and only at that point.
2 years later, he shows up?
Yes.
So you're arguing if he showed up 5 years, 10 years later, it's all okay because that's when he realized that there was a problem? That's a reasonable mistake?
I can't answer that. I don't know what would have been ratified by then. I know that in these 2 years.
Okay, so let's go back here. You're saying it was reasonable for him not to seek clarification or anything for 2 years, but then you're saying discovering it 2 years later, that's reasonable?
That's a reasonable excuse, I guess, what you're saying.
Yes, he doesn't know that there's a problem. Nowhere in the separation agreement, in either one of them, and nowhere in the judgment of divorce.
Okay, let me ask you this. So the 2-year period where he didn't go and ascertain that there might be a problem, he did that because the agreement provided for such, or he had no reason to figure it out?
He had no reason to believe there was a problem. His understanding was he could get the barn when he obtained a property to go to the barn. And in those 2 years.
I think we understand
Okay.
your argument on reasonable excuse, and
Thank you.
I think we have the basis of the balance of the rest of your argument.
Thank you. Just one brief second. I do want to note that, remember, he continued to pay on the $30,000 loan. He thought it was his barn. Plaintiff allowed him to continue to pay on the $30,000 loan. Thank you, Judge.
counsel.
Good afternoon, Your Honors, and may it please the Court, Laura Ashikaga on behalf of Donna Van Damme, the plaintiff respondent in this matter. First, as was pointed out by Justice Troutman, there is no plenary action in this matter. The defendant filed a motion to vacate with respect to the party's judgment of divorce. As set forth in our brief, we do not believe he has met the standard for a motion to vacate under the factors enumerated under the CPLR. Further, although
If you win on that point, are we done?
that would be my position, Your Honor. If the judgment isn't vacated, then the separation agreements must remain as they are since there's no action separately to vacate those. If there are no further questions,
no
I
further
will
questions.
rely on my brief.
Thank you, counsel.
Thank you.
Case 899.1, Ross versus State of New York. So do we have the chairs set up appropriately, counsel?
Thank you, Your Honor.
Very good. There was a request, before we get going, Mr. Savino, there was a request that the order of the arguments of appellants be Mr. Savino, Mr. Fusco, and Mr. Ciampoli. Has that been agreed to by the appellant's counsel?
I have not asked my opposing counsel.
Not opposing counsel, the appellant's counsel.
Oh, yes, we've all three agreed.
You've all agreed to argue in that fashion?
Yes.
Any objection to having the argument be done in that fashion, counsel? All right, we're going to proceed in that fashion. Let's make sure we keep our masks up, please. Thank you.
Your Honor, may it please the court. Plaintiff's argument as to the significance of Article 2, Section 2 of the Constitution is not that absentee voters must be ill, but that the reason they are unable to vote in person is based on actual illness, not risk of illness. For example, a qualified voter who is not himself or herself ill can still vote
absentee based on actual illness when caring for someone who is actually ill. Under Article 2, Section 2, healthy, qualified voters should not be permitted to vote absentee because they have subjectively and unilaterally determined they're at risk of contracting or spreading a disease at the polling place. Chapter 139 of the laws.
Mr. Savino, are you suggesting that the pandemic is a subjective analysis? In other words, that COVID is subject to everybody's interpretation, and some people may think that there's a risk involved, and others may not, and that should be determined? That should determine the issue here?
It is definitely a risk, but I went to a football game where there were 80,000 people there, and they went to a game. If they can go to the game, they can go to the polling place. All those people, 80,000, were double vaxxed, a majority.
But the people who choose not to take the risk by going to the football game, they're not losing a right. They might be losing some time and entertainment, but they're not losing the right to vote because they're fearful. But you're saying they can't be fearful of going to vote and stay home without losing the right?
Your Honor, this is a situation where, like Bankers Association, we shouldn't be looking at the merits, we should be looking at the conflict with the Constitution. I think it might have been a good idea to have a law such as this, but it wasn't done within the delegation by the Constitution to the legislature. And that's the problem. They could have done it correctly by having a special ballot under Article 11, Section 300 et sec of the election law. They did it by the executive order of Governor Cuomo until it expired. But this law, as admirable as it may be, conflicts directly with the Constitution. Now, Your Honor, it's our position that in enacting Chapter 139, the legislature exceeded the authority granted by Article 2, Section 2 of the Constitution and violated the spirit of absentee voting under the Gross case, a 2004 Court of Appeals case, which actually rejected absentee ballots for a special election that were issued by the Board of Election on prior application. There was an original election, people requested an absentee ballot. A federal court said, no, we've got to have a special election, and when it came time for the special election, the Board of Election relied on the initial applications for absentee ballots. And in Gross, the court, even though you'd say you are depriving people of a vote, the Court of Appeals said, we're not going to allow those people to vote absentee ballot, and the absentee ballots were struck on appeal. What Gross emphasizes is that absentee ballots should only be available in limited circumstances. The application for an absentee ballot considered by Gross is identical to that being used currently in 2021, and that's exceedingly important. And we've tried to emphasize that more on appeal. What we know from Gross is that the signature on an application for an absentee ballot carries the same penalties as if duly sworn. New York must maintain its detailed scheme for issuance, collection, and canvassing of absentee ballots. New York's comprehensive statutory scheme was created in 1920 to ensure fair elections by protecting voter privacy and the integrity of the ballot, both expressions taken directly from Gross from 17 years ago. The absence of secrecy for absentee voting requires heightened safeguards to protect against, quoting the Court of Appeals, fraud, coercion, or other types of mischief. Gross teaches us that the sanctity, the court's word, of the election process is best guaranteed through uniform application of the law. Due to the unrevised application form, each Board of Election, with the duty of inquiry, won't be informed by the 2021 application if the applicant is actually ill or applying because of a concern of contracting.
Does the plain language limited to one who is actually ill?
The language on the application right now, Your Honor, has two boxes that the media are saying people concerned should check. One says actual illness, and the other says permanently disabled. And one of the reasons why that second thing is a nightmare, where you have New York State, AP, Newsday, other media telling those concerned about risk of contracting or spreading disease to submit an application for an absentee ballot checking either box indicating an actual current illness or worse yet, permanent disability. These instructions create the absurd result that if someone has, what Your Honor described, a temporary fear during the pandemic, but checks the permanently disabled box, that person, with this law, this vague as applied law, that person would automatically receive absentee ballots for the rest of his or her life, even after the pandemic is over. That's the kind of absurd result of a section of the law that doesn't give any guidance to a board of elections. They do not know when that application came in on what the applicant is asking for the absentee ballot. Just going back, Your Honor, to some other points on gross. The Board of Elections has a duty to assess the validity of the application for an absentee ballot before issuing the absentee ballot. It must determine if the applicant is a duly qualified elector. The absence of a separate box for those applicants concerned about the risk
So
of
you're saying it's unconstitutionally vague?
Yes, as a due process proposition under Goldberg and otherwise. We believe it's unconstitutionally vague on its face, Your Honor, and also as applied. The application, it's just a nightmare. It's going to be arbitrary because there is no guidance. What does a person on a board of elections do? They look down and they see permanently disabled check. What do they do? If somebody's fearful of the pandemic, that might be the reason that box checked. Gross, again, the people who lost their vote in Gross were innocent. They weren't told to submit a new application. But even though they're innocent, the court took their vote. And what the Court of Appeals said is, innocence of the applicant is irrelevant under Gross because, quote, exception based on voter innocence would swallow the rule. Gross requires strict compliance to reduce the likelihood of unequal enforcement and to maintain, quote, the sanctity of the election process, which can best be guarded through uniform application of law.
So you're arguing the ordinary citizen isn't on notice here as to what is required?
Yes, but they may know that there's the prospect of applying, but they and the Board of Elections are given no guidance. There's no substance, there's no demarcation.
The enforcement aspect becomes arbitrary?
Right, and what compounds that is an expression. I'm a business litigator generally. Your honors have seen me here before. As a business litigator, the language in 800, as drawn last year by the legislature, says, including but not limited to. That's limitless. Including but limited to just means a couple of examples were given.
Okay, so you argue here the presumption of that it is constitutionally valid, you've overcome it.
I believe I have, Your Honor. And one of the things that helps us is, and we've tried to bring the point very directly. When you look at Article 2, Section 2 of the Constitution, which must be inviolate, even when a law may have merit, when you look there, it says who can have an absentee ballot and gives the legislature how, when, where an absentee applicant can cast the ballot. And under Silver, we learned that where there are exceptions specified by the Constitution, then those exceptions are treated as the universe of what the legislature can do. That's the doctrine, and I love saying the Latin, expressio unius est exclusio alterius applies to determine a grant of authority by the Constitution to the legislature. Tellingly, that doctrine is consolidated in McKinney's in Book 1, Statutes 240, quote, where a statute creates provisos or exceptions as to certain matters, inclusive of which provisos or exceptions is generally considered to deny the existence of others not mentioned. So just as certain enumerated exceptions were specified in Silver, here Article 2, Section 2 said the legislature can only legislate as to how, where, and when absentee ballots can be issued and used, but not who can use them. Silver held there's not a carte blanche, and that was the exact expression, to the legislature where you have these enumerated exceptions. And again, it said the legislature cannot accomplish by indirection. So here, what they're trying to do is, where Your Honor is correct, everybody has some degree of fear, every rational person has some rational degree of fear about COVID. This legislation would essentially accomplish what is on the ballot next month, which is absentee ballots available to all. It's not in the Constitution yet. They've jumped the gun. Chapter 139 would effectively allow anyone to vote by absentee ballot. That is an impermissible ultra-virus extension of the limited grant of absentee ballots in the 1976 Amendment to Article 2, Section 2 of suffrage. It isn't.
Mr. Savino, you should begin to start wrapping up.
Your Honor, you've been here a long time. I'm going to do something amazing and shut my mouth.
Counsel, thank you.
Good afternoon, Your Honors. May it please the Court, Adam Fusco for the Republican Commissioner of the Niagara County Board of Elections, Jennifer Sandinato. Your Honors, as an initial matter, respondents had raised in their briefs the question of standing and whether the appellants have the requisite standing to bring and satisfy this action. I'd like to address that in two parts. First, it is our position that the argument of standing has been waived and is not properly before this Court. As an initial matter, in respondents' briefs and in the motion to dismiss by Mr. Del Monte before the trial court, the declaratory relief sought there cited not to CPLR 3211A3, which is the legal capacity to sue, and did not properly preserve that issue for review by this court.
Did Ms. Sandinato formally participate below?
Yes, Your Honor. I represented Ms. Sandinato at the trial court below and adopted the arguments of the appellants here as my arguments below.
So that adoption is sufficient to allow her to participate now?
Your Honor, yes. I would argue that that is sufficient, but more importantly, that issue was not addressed by any of the respondents before this court, and that argument was not made that I have not properly joined the appellants.
She didn't have to answer the complaint? Or did she?
Your Honor, a notice of appearance was entered, and I made oral arguments at the trial court below on behalf of the commissioner.
During the motion argument only? In other words, you didn't put in a notice of appearance in response to the initial pleading, right?
No, Your Honor. I was retained after that period, but before oral arguments.
Right. Yeah, and counsel, I'm gonna say again, and I'm not gonna say it after this, if you can't keep your mask up, I'm gonna stop your argument, you're gonna be asked to leave the courtroom. Do you understand?
Understood, Your Honor.
Okay.
And so to the point of standing, what I believe the respondents have before us is an alternate ground for affirmance. That party that obtains an order in its favor is not aggrieved by it, and consequently has no right to appeal. And they have not cross-petitioned or
What did she ask for here?
The
Your
same.
client.
I'm sorry.
What did your client ask for that she was not given?
My client asked for the same relief as the appellants, that section, the 139 of the laws of 2020
By
be
adoption
deemed
of their
unconstitutional.
positions?
Correct. And so consequently, they have no right to appeal on the issue of standing, and this court held that in the matter of Vendetti versus Erie County Medical Center Corp. In 2015. Now, should Your Honors get past the argument that standing is before this court, then I would point to two things. One, that the appellants have standing as qualified voters. That is the matter of Wright versus County of Cattaraugus in this 4th Department, as well as Saratoga County Chamber of Commerce versus Pataki, a 3rd Department case from 2000, which says that in a constitutional matter seeking a declaratory judgment, qualified voter status is sufficient to sustain standing. The second part is that the appellants also are citizen taxpayers. In the Scholes trilogy of cases and State Finance Law 123-B, citizen taxpayer standing is sufficient to sustain a cause of action when you are moving a court for a declaratory judgment to declare a statute unconstitutional. So dealing with those matters of procedure, I now move to the procedure that the legislature ignored, which is the proper way to amend the state constitution. Whether we talk about clarification, amendment, adding clarity to, in effect, what this statute did is it changed the class of eligible absentee voters under Article 2, Section 2 of the state constitution. But it ignored or circumvented
What additional group of voters was added to the class of voters? What new voters became part of that new class?
Your Honor, currently New York State is still a for-cause absentee voting state. What this statute did is it expanded the class of people who could vote by absentee, expanding it not just to those who have...
I mean, those all fall into the category of registered voters, right? You can't seek an
Correct.
absentee ballot unless you're a registered voter. So the class of voters are the registered voters.
But the class of those who would vote by the method of absentee as opposed to at the polling place.
But they're not expanding the class of eligible voters.
No, you're right. You're correct, Your Honor. They're expanding the voters who would use a paper method of voting as opposed to being in the polling place.
It's simply the method.
The method.
The how.
The how, exactly. And Article 2, Section 2 lays out the how, the where, the when, and the why. But it's Article 19 of the state constitution that outlines how the constitution is to be amended. Again, it's our position that this standalone legislation does in effect amend the Constitution by changing that method. However, we look at Article 19 of the state constitution, which requires passage by two consecutive legislatures.
So it's more than clarifying what illness means?
Correct. The strict construction of the Constitution, illness is not defined in the state constitution. This bill creates this law creates a definition for illness. It creates an expansion of illness, and by effect amends the state constitution.
If there was no definition before, is that truly expansion as opposed to clarification?
I believe it is, Your Honor. It's clarification and expansion. But by any word that we use, it does in fact amend what is the state constitution and what the state constitution provides.
And your argument that the manner in which it was done was improper?
It was improper. And even if the intent is laudable, right, to try to reduce or mitigate the effects of COVID-19, to keep people from congregating in tight spaces or being less than 6 feet apart, even if that intent is laudable, the legislature jumped the gun. They did not do a concurrent resolution of the Senate and the Assembly.
Your argument is how they did it was impermissible.
Exactly, Your Honor.
And therefore not valid.
Exactly, and not to the merits of the bill itself, but the procedure by which the legislature did it. And as my client has the obligation or the duty under Article 9 of the election law to investigate, verify, and determine the veracity of whether a voter is a duly qualified electorate. This statute makes that duty for my client and for these boards impossible to follow. Right now, it's not possible for the board to look at an absentee application where someone has checked the box temporary illness or disability and ascertain whether that person has COVID or has a fear of the risk of COVID. So whether they're exercising their ability to vote by absentee based upon the challenged law here, or whether they do in fact have an illness, it's not possible for the board to determine which one of those two things is going on.
How is it different from how they made that determination in the past?
So right now what happens is the board would intake the application, and ultimately there would be an absentee ballot delivered to the board. At that point, the board sua sponte would investigate whether or not that person has an illness. They have the ability to do so under Article 9 of the election law.
Right, but there isn't necessarily automatically a hearing or anything with
Well-
respect to, you attest that you're seeking absentee ballot based on a status that's provided for, correct?
Correct, but what would happen in that instance, Your Honor, is that an attorney can bring an action before the board to challenge the veracity of that vote.
Correct.
Which would be a condition precedent
So
to
how
either.
is that different now than before? They still could do that this person did not qualify.
They could still make that same challenge that this person is not a duly qualified electorate, but there would be no way to actually send, for instance, an investigator into the field to verify whether someone's ill. It's so subjective, it's not possible for the board or for an attorney bringing a case before the board to determine whether someone is subjectively fearful of the risk of contracting COVID and that's why they checked the box.
The fear of contracting COVID is not an illness, and therefore persons who may fear COVID have no right to vote absentee based upon the manner in which it was done by the legislature here.
Correct, Your Honor.
Thank you.
Correct. And the one thing I would add to the board's duties and obligations is that under Article 9, Section 209 of the election law, which was recently amended by Chapter 141 of the laws of 2020, the boards already have had the ability to notify voters within 7 days that they need to cure an otherwise defective absentee ballot. And so here we are on October the 18th, 2021, less than 2 weeks before Election Day. And it would be the position of my client and of the appellants that the relief sought herein can be effectuated. That probably between now and roughly October 26th, should a decision be handed down in favor of the appellants, that the board has the ability to contact all of the voters who have sought an absentee application, who have filed an absentee application with the board and intend to vote by absentee, and notice them that, in fact, this statute is unconstitutional, and unless they have an actual physical disability or temporary illness, or a permanent disability or illness, that would be the only, or if they were out of the county, that would be the only prescribed method for voting by absentee.
Very good. Counsel, anything further?
Nothing further, Your Honor. Thank you.
Thank you, Counsel.
I believe it's good afternoon at this point. May it please the court.
It has long been good afternoon.
Yep. May it please the court, John Ciampoli for Senator Ort and Assemblyman Barkley, the minority leaders of the Senate and Assembly respectively. If I may take a little bit of time to address a clerical issue. Errata on page 18 of my brief, I referred to referendum number 2. It's actually referendum number 3. The State Board of Elections ordered them differently than I saw them before they were published. Mr. Savino has mentioned an Associated Press article published in Newsday. I'd ask leave of the court to provide the court with the web address at which you could find that article.
I'm sure we can find the article if we need to see it.
Okay. And addressing the standing issue that the court raised to Mr. Fusco, I believe that issue was conclusively resolved by the sister appellate division in the 1992 case of Piscazzi versus New York State Board of Elections and David Gamache. Again, if the court wishes me to provide the citation for that case, I can do it. I do it from memory because it was my case. Your Honors, I've said in my brief that a rose by any other name would smell as sweet, and an amendment by any other name is still an amendment to the Constitution. What the court below did was the court bought into the intent of the sponsors, which was to expand the people who were eligible to vote by absentee. The Court of Appeals has addressed that, both in the Gross case, which Mr. Savino has cited to you, and in the Bankers case. In Bankers, the court said without equivocation that the purpose of the action of the legislature matters not. It is whether or not the act is constitutional. Here, Judge Sedita's decision talks about what is added to the Constitution, using terms like it gives it more structure. It takes a vague passage and gives it more definition. Those are amendments. Those are changes to the Constitution because the general construction law says how the Constitution is supposed to be interpreted. It says you take the ordinary meaning of the word. Respectfully, Your Honors, neither Justice Sedita nor this court nor the Court of Appeals has the power to amend Webster's dictionary. That's the ordinary definition of the term. And that's what was done here. Let's take a look, and Judge Sedita did not look at the intention of the sponsors, the legislative intent. And this court needs to consider that legislative intent, and you have the bill jacket in the record of this case. The sponsor's memo talked about the CDC saying how people at risk were to be sheltered and to be spared any exposure to COVID-19. Well, the sponsors went on to assert that these restrictive criteria in the Constitution do not accommodate people who are concerned about the risk of voting in person that would pose to their own or others' health. Okay, that is in the sponsor's memo in the record of this
Counsel,
case.
your argument, because you believe that the statute's vague, that we have to go to legislative history to then interpret what the meaning was in the statute, is that where you're at on this?
Well, I believe I'm taking a two-pronged argument. Obviously, I believe that the legislature has violated Article 19 of the Constitution and it acted improperly, and under Bankers, that is enough for this court to determine the statute unconstitutional. I also have adopted Mr. Savino's arguments on vagueness, and you had a discussion with Mr. Fusco. There's no way you can tell what the reason is for issuing an absentee ballot. And, you know, the court is probably going to say I had insufficient evidence in the record on this, and I should have had an evidentiary sticker placed on my forehead, because they talk about protecting people with pre-existing conditions. So here's the question. What did the legislature do, and who did they do it for? Because as Mr. Savino pointed out, and as this court has echoed, this is not about the method, the time, the place, the how a vote is cast. This is about who is eligible to cast an absentee ballot. Well, I have a heart condition. I have a pre-existing condition. That's an illness. I could check the temporary illness box. I didn't need this law. So who's protected by this law? Who's given more rights by this law that are not provided in the plain language of the Constitution? The people who are perfectly healthy. And again, as I pointed out, it doesn't matter that this is, you know, well-intended. But we met those arguments at trial term as well. We pointed out to this court that there is no report in the elections that have been held since the pandemic, and while the state of emergency existed, resulted in super spreader events. I represent a special district down on Long Island. It provides sanitation services to some 30,000 to 50,000 people in the area of the town of Hempstead known as Oceanside, and we have in the record the report on that election. We conducted that election safely. We had masks. We sanitized pens. We sanitized the sanitation garage where the election was held. We had social distancing. Not a single report of someone getting COVID by coming out to vote came out of that election. And there's one point I'd like to make. In special district elections such as that, we had no absentee ballots. And we had a near record turnout of voters. And they came out and voted because that's their right and that's what they wanted to do.
I think we have that argument, counsel. Anything further?
I would like to close by saying there was a proper way for the legislature to do this. And Mr. Savino mentioned it very briefly. If you go under Article 11, Section 11-300, there are a variety of special ballots that the legislature has provided for, and never has a special ballot been successfully challenged for unconstitutionality. They could have done it right. They could have said, we're going to issue a special ballot during a period of emergency, or a special ballot during the COVID period of emergency. What they did here is they changed the law, and we now have, as Mr. Spino already mentioned, we have the Associated Press telling people, check the, and they cite to the State Board of Elections as providing their information. Check the box that you have a permanent disability. Well, that's false. You may be afraid of contracting a disease, and this was written in vanilla language, it's any disease. We all know what they really meant. But the fear is not, again, is not an illness, and the misinformation that is out there is going to pollute the election process.
Counsel, we have your argument, counsel.
It makes someone eligible to vote by mail. That is not the law of this state yet. Thank you. I thank the court for its time.
Very good. Thank you, counsel.
May it please the court. Brian Ginsberg for the majority defendants. Article 2 of Section 2 authorizes the legislature to allow absentee voting, quote, because of illness. That provision expands voting access, and as a result, it should be interpreted broadly to effectuate that purpose. Moreover, in the provision, there is no express textual requirement that the illness be one that the voter is presently and personally suffering. Accordingly, Article 2, Section 2 is properly read to authorize absentee voting not only because of illness that the voters currently have, but also because of illness that the voters risk contracting from others, that others currently have. And indeed, the text of Article 2, Section 2 affirmatively suggests breadth in this area, namely by the use of possessive pronouns applied to other terms, but not the term illness, particularly as Article 2, Section 2 was amended in relevant part in 1955. And that's not just me saying that, that's also the unanimous Connecticut Supreme Court in the Fay versus Merrill case, analyzing an analogous provision of that state's constitution, which I didn't hear my friend's response to at all. Now, my friends say that doesn't the 2020 legislative amendment give illness an odd meaning by incorporating the notion of risk? And the answer to that is yes. When it comes to the use of the word illness in the statute, the legislature surely could have proceeded a little more artfully, perhaps using the because of illness language that I quoted at the outset. But there's no amendment of what the words of the phrase because of illness mean in the Constitution. And that's what's relevant for the question of authorization.
What about the argument that it simply was supposed to have its ordinary meaning as it was stated in the dictionary.
Your Honor, I couldn't agree with you more. Illness does have illness as it appears in the Constitution, which is the authorization question here, does bear its ordinary meaning, a condition of being unhealthy or a specific disease. The point is, in the Constitution, there's no limiting language in a provision that otherwise needs to be read broadly to effectuate the intent to expand access to the electoral process, limiting that unhealthy condition or specific disease to one being presently and personally suffered by the voter. And that it's the same constitutional footing that supports the caretaker provision, which plaintiffs on the other side concede is constitutionally valid. There, it's because absentee voting because of illness that is presently being suffered by someone in the voter's care. In this instance, it's because of illness that's presently being suffered by other persons who may go to the polling place and transmit that illness to the voter if the voter is prevented from voting absentee. Nor does the state's position here, the majority defendant's position here, transform this into a system of no excuse absentee voting, such as will be on the ballot in the general election. I mean, to be sure, as long as COVID remains prevalent and potent, it will be a system of everyone probably has a good excuse voting. But when COVID subsides, there's going to be much less, I would think, absentee voting because of illness, because there are going to be fewer illnesses that present the risk of community spread so potent as to make voters expect to be, quote, unable to appear, which is the constitutional and statutory language, at the polls.
Here, the argument is that those who have the responsibility to enforce, it's being made difficult for them to enforce based on what you just stated.
I have been hearing that, Your Honor. I guess a couple responses. Number one, I would always I'd caution the court to be careful of fairness arguments asserted by proxy. You don't have voters coming here before you saying that they can't figure it out. You've got you've got the enforcers saying that they are having trouble, or at least one enforcer, my colleague Mr. Del Monte, I'm sure will say that his client is not having trouble with it, a fellow Niagara County commissioner. But in any event, there's no vagueness argument here being made by actual voters saying that we will try to vote absentee and we can't figure it out, so it's going to cause us to decline to exercise our right to vote altogether. That sort of prerequisite for any vagueness claim is absent here. But I want to be directly responsive in another way as well. What I hear my friends saying on the other side is that the ballot application is not detailed enough. The administrative machinery of county boards of elections is not detailed enough. I mean, with respect, that's the tail wagging the dog as far as constitutional analysis goes. If the application needs to be more detailed, then create a more detailed application or lobby the State Board of Elections to create a more detailed application. That doesn't drive the constitutional analysis either as to authorization or as to vagueness. Because again, this statute, there's no argument that it was vague before this sort of redefinition or partial definition, elaboration of the word illness was enacted. And now there's only more content, more structure for that word as opposed to less. Quickly on the issue of standing, there is no standing here. The plaintiffs have not alleged the necessary injury in fact, nor have they alleged the applicability of any exception. The fact that some of them are qualified voters is not enough. You can't just say voter and have that be the magic word. For example, in the Wright case that one of my colleagues on the other side mentioned, there was a weighted voting plan at issue, so the plaintiffs' votes were being counted less equally or they were being devalued as compared to the votes of others. In this context, though, at the end of the day, both before the 2020 legislative amendment and after it, everyone's vote counts the same relative to everyone else's. There's just an influx of more votes. The denominator is likely going to be bigger, but that is the prototypical generalized grievance As we say, and as we cite the 11th Circuit case in Wood and the 3rd Circuit case in Bognet in our brief to say that all voters experience, there's nothing special, concrete, unique to these voters. So, Your Honor, unless there are any questions, we would ask that the court affirm this measure is constitutionally authorized and not constitutionally vague. The plaintiffs have not met their burden, and that's if you get to the merits at all. We think there's an adequate ground for affirmance for lack of standing as well.
Counsel, thank you.
Thank you.
Mr. Delmonte?
Yes. Good afternoon, and may it please the court. I'm taking a quick look at the clock, and I understand the constraints that everybody
No,
is,
please, you have
paying
an opportunity to
attention
make your argument, please do.
But thank you for the opportunity to be what I characterize for myself as almost the wingman on the arguments that have already been presented in such great detail by both sides, but particularly by my co-counsel on the respondent's behalf, Mr. Ginsburg. I'd like to raise just, or follow up a little bit more on the question of standing, because it's been challenged that in my motion on behalf of Democratic Election Commissioner Laura Allen, that I didn't properly identify that as one of the grounds for my application to have the complaint dismissed. And I think I did recite 3 subparagraphs under Section 3211 of the CPLR, but I may have overlooked or not included the one referred to by opposing counsel with regard to capacity to sue. But I would respectfully offer to your honors to take into account the supporting papers beginning at page 151 of the record, where I clearly caption the argument being made on behalf of my client that there is a lack of standing, and substantively we address the issue head-on in that section of our moving papers. And if I have to go so far as to also reach out to the language of the wherefore clause, where we seek such other further and different relief offered or potentially available to the client in connection with the matters being argued, then I do reach out for your acceptance of that as a grounds for the lack of standing argument that we made. The lack of standing in this case, I think, is almost illuminated now by the cross arguments that we've already heard about who the plaintiffs are in this case. None of them have an acute or direct, nor have they alleged in their complaint or in any of their moving papers, a true and actual injury to the franchise, to the voting franchise that they somehow believe has been violated by this law that they contest as unconstitutional. We do not have before us a voter who would be making the claim that they sought an absentee ballot based on the specific provisions of this statute and was denied the granting of that ballot. And we do not have a voter before us, before this court, saying that they made an application for an absentee ballot and it was granted to them, and now one of these plaintiffs say that was done to our detriment. We have nobody before the court on this record who can claim an actual injury to what has been given or not given, granted or not granted, in the manner by which somehow the right to exercise the right to exercise a vote in any of the contested elections has somehow created or caused harm to any of the plaintiffs. The statute in question is a general law. Article 2, Section 2 of the Constitution grants the legislature the right to pass a general law describing who would be entitled to receive an absentee ballot. Part of the argument I've made on behalf of Democratic Commissioner Laura Allen is that even though there was an amendment to Section 8-400, subsection 1, subsection B, as to how the qualification for eligibility to get an absentee ballot was modified by the legislature last year, the legislature did not tamper or touch or alter or impair or change or diminish or do anything to cause the powers, rights, and duties of the County Board of Elections Commissioners under Section 8402 to examine each and every application brought either sua sponte, by themselves, or to some extent contested or brought to their attention by someone complaining of who might be seeking and be eligible to receive an absentee ballot based upon the provisos now of the amended statute. Not one complaint is before us in this record that shows or in some way establishes beyond mere conjecture that the elections commissioners somehow have been deprived or had the power and authority given to them under 8402 compromised or diminished to execute exactly what the law has allowed them to do historically with regard to all absentee ballot applications. That is a big deficiency in the argument that's been presented by the plaintiffs in this case. They don't have one mere or slight reference or example to argue that the law as it's always been has now been somehow altered or impaired because of this statutory amendment.
We'll take a hard look at that, counsel.
And thank you for the opportunity to make the final argument in
Thank
this
you,
case with
counsel.
your honors this morning. Thank you.